Just kind leave to mention one matter, leave for filing appeal without certified copy. Direction for demolition of my construction without any proceeding under 218. 19 July order has been passed.
19 July.
19 July. And certificate copy today because yesterday I have received the notice with the order.
Give the number, it will be listed tomorrow. Serve notice. Serve notice.
Monday, my lord.
Monday.
Have to serve notice Monday.
Monday.
Permitted to mention one matter, my lord, for inclusion in the list. Lordship, may I, Lordship, I am the appellant in this matter, your Lordship. Lordship, they are mentioning one CAN application in this matter which has not been served, your Lordship.
If they don't serve it, they will not get any order.
Lordship.
It is at their peril.
Lordship.
My lord, may I permit to mention two applications, my lord. Same order, my lord, compassionate happened. Other 25 matters.
Oh.
The lordship has the order. Same.
May I have?
Last two matters.
Please bring one of those orders.
Yes.
Bring one. Hey, tomorrow? Tomorrow for orders. For orders at the top.
Application.
No, then it can be disposed of immediately. At the top for orders.
May I have my lord's kind leave, my lord, to move, my lord, to urgent applications in connection with a mandamus appeal, my lord, at 2 p.m. my lord, today. My lord,
No, Mr. Banerjee, inflexible rule is that however urgent the matter be, it has to be listed. So tomorrow top.
My lord, may I just indicate, my lord, the urgency? I know, my lord, this is, my lord, inflexible.
Yes, yes.
My lord, today at 2 p.m., my lord, the matter is fixed before the Honorable, my lord, single judge. This, my lord, pertains to, my lord, that Ulubedia SDO and BDO matter. My lord, I have preferred an appeal, my lord, on behalf of, my lord, the subdivisional officer. My lord, the case of the block development officer and, my lord, the subdivisional officer, to my understanding, is, my lord, polls asunder. My lord, absolutely different a case. And, my lord, today, my lord knows, my lord, there is already a direction, my lord, passed by the Honorable Single Judge for initiation of disciplinary proceeding, for putting me under suspension and all that.
Tell the learned judge that you have filed an appeal.
Very well.
But tomorrow at the top.
Very well. Very well. May I, my lord, file the application and, my lord, supply the number to my lord's court
Yes,
office?
yes.
Grateful.
Kalke diye debe.
And may I have my lord's indulgence?
Serve.
May I have my lord's indulgence, my lord, to, my lord, inform the Honorable Single Judge that, my lord, today the matter was mentioned and, my lords have been kind enough to keep the matter tomorrow at the
Tomorrow at the top. But not that we have told you to mention this to the learned judge.
And I follow. Grateful. Leave the number. Okay.
For judgment.
You need to. Who is for the appellant?
No.
You are for the appellant?
No. I'm repetition respondent.
You are assisting Mr. Vikash Ranjan Bhattacharya?
Yes, Your Lordship.
We are for the Kolkata Institute.
Judgment.
তো আগে থেকে বলতে হবে। হ্যাঁ। হ্যাঁ, হ্যাঁ। Now it appears that the order of injunction passed by the learned civil judge junior division, second court Alipur, South 24 Parganas on 12/5/2022 was not brought to the notice of the special municipal commissioner, and as such he has passed the order as aforesaid without considering the effect of such order. That order was affirmed by the first appellate court. In our opinion, as the competent civil court have already allowed the appellant to carry on his construction at the relevant property, after considering the relevant documents, we think that the order of the special municipal commissioner passed on 5/7/2022 cannot be sustained at this stage. We have also considered the case law of Manohar Lal dead by legal representatives Supra, and in our opinion, as the competent civil courts are prima facie satisfied with the contention of the plaintiff appellant as to his title to the property, we think that the ends of justice shall be best served if the appellant is allowed to complete his construction on the relevant land subject to certain conditions. Accordingly, the order dated 5th July 2022 by the special municipal commissioner suspending the relevant sanctioned plan of the appellant being number such and such is hereby set aside, and the original plan is restored. The impugned judgment and order passed by the learned single judge in WPA number 22925 of 2022 and WPA 15466 of 2022 on 29/3/2023 is also set aside. The two appeals stand allowed on contest, but without any order as to costs. The connected application, if any, is disposed of. We make it clear that we are permitting the appellant to complete the construction work, since keeping the structure in its present condition will not only or to anybody's benefit. On the contrary, the structure is likely to undergo serious damage. The interior of the structure is exposed to the elements of nature, as the doors and windows have not yet been fitted. Society's valuable resource is likely to be wasted altogether if the structure is directed to be kept in the present condition. The appellant is at liberty to carry on with the construction work in accordance with the previously sanctioned plan, subject to the conditions that he or his agents, partners, and any other person under him shall not use the property nor create any third-party interest in respect of the same, nor transfer the said property in any manner whatsoever without the leave of the competent civil court of law. However, the appellant will be at liberty to undertake regular maintenance work if the same is required to keep the building in a proper condition. Secondly, the Kolkata Municipal Corporation shall not issue completion certificate to the appellant or his partners, agents, etc. until final adjudication of title dispute between the parties. Thirdly, both the parties shall expedite the conclusion of both the suits filed by them. Fourthly, the appellant, his main agents or partners shall not claim any equity for carrying on construction and completion of the same, and in case it is held by the competent civil court that the appellant has no title to the land as referred to above, he shall remove the entire construction at his own cost. The learned civil judge at Alipur, dealing with the matters is requested to dispose of the suits as expeditiously as he or she can without being influenced by any of the observations of this court made in this appeal. এখানটা একটা কিছু হয়েছে। Anyone. There is orange. That's all. সার্টিফিকেট পাবে না হ্যাঁ সিভিল কোর্টে গিয়ে দেখতে হবে ওখানে তোমাদের যা
You will not issue CC.
yes madam we have
You see why we have,
that dispute is civil dispute
yes, why we have done this, keeping that building in this condition will not inure to anybody's benefit. The society's resources will be wasted. He can carry on, but he will not claim any equity. He will not use it. He will not transfer it. No third party interest, nothing. He can construct, complete and maintain, subject to what the civil court decides. Gratefully. এই দুটো পাতা পাল্টাতে হবে দেখেছো? আমাদের বাড়ির অবস্থা
New application, item number 1.
This matter.
Mr. Ghosh, this we remember,
Hello.
Mr. Raghunath Chakraborty.
Yes, madam.
We are actually in the process of writing the judgment.
We may wait, last time I told my learned junior
Yes.
that we may wait for some more time.
Fortnight. It should be done by fortnight. Mr. Chakraborty Junior, you are there. Is there an interim order? No. Very well, then simply
To final reply, my lord.
reply. Reply to what?
Well, we filed a cross objection. There is a, on the last occasion, she said need not want to say anything, which is the ground of appeal. কিসের objection আমি বুঝতে পারছি না।
Keep it with you. We are adjourning and you know nothing about the matter because there is an interim order. Till the 10th of August, we will extend that. देखो, it is expected that the other matter in which similar legal points are involved, comma, will be decided within the next fortnight. Stop. Paragraph accordingly, comma, let this matter stand adjourned for a fortnight and be listed again on তারিখটা দিয়ে দাও হ্যাঁ আজ কত তারিখ তার মানে 17th paragraph the interim order that is in subsistence shall continue till August 22 or until further orders whichever is earlier.
There is a directions on the last order, in the last order, that OCOT to be listed also, my lord. The last part of the OCOT order on the
OCOT number 3
of 2020, that has not been, my lord.
not been listed. কেন হ্যাঁ কেন করবে না দিয়ে দাও it will be listed. Yes.
My lord.
Super.
Lord, item number 2, I'm paying for a short passover.
Item number,
2, I'm paying for a short passover.
how short?
Just coming. In the matter.
Coming from where? Passover, sure.
Item number 3 and 4.
My lord, 3 and 4.
Paying for the short Passover in
3
this
and
matter,
4.
my lord.
My lord, Mr. Shuddha Sattva Banerjee is my lord appearing. My lord, he is suffering from viral fever from yesterday night. My lord, at least.
He was here yesterday only.
No, yesterday night, my lord, he has my lord suffering.
By viral?
Yeah.
Wait, how long?
My lord, Monday. Okay, because of a viral fever, at least my lord, 3 days. My lord, he requested.
Very well. Is there an interim order?
Yes, my lord. My lord,
Till what time?
my lord, tomorrow.
Nobody can oppose personal health ground. We are told that Mr. Shuddha Sattva Banerjee, that learned counsel for the appellant is suffering from viral fever since last night. And stop. Accommodation is sought for on his behalf. Paragraph, let this matter stand adjourned and be listed again on Monday. Did they though? Monday, stop. The interim order that is in force, comma, shall continue till August 11, 2023, comma, or until further order, whichever is earlier. Next matter, just simply adjourned. There is no interim order in the next matter.
No.
Simply adjourned till Monday.
Morning 6:30, my lord, he called me. And that I am suffering.
No, this is happening in every household.
Yes,
Be
because of
careful.
the viral fever is not going on every house because of yesterday my daughter they are 2 days back my daughter also suffering.
You file a PIL, get an injunction against viral fever.
Item number 5.
My lord, I appeal for the alleged contempt in this matter, my lord. We have already complied with, my lord. We have already filed, and your lordship has also said, my lord, to file reply to their exception, my lord. And we have also prepared that, my lord. We have already said, my lord, that it is now up to the, my lord, the local school to get the order to give order and to get, my lord, the stock and all that, my lord. But we have, my lord, already, my lord, started complying.
Lordship, on the last occasion, my lord, kind leave was granted to me to file a supplementary affidavit, my lord, to give the details of the blind schools. My lord, on account of the illness, my lord, of the petitioner, my lord, it could not be affirmed, but I have the list with me.
No,
But
In this, my lord, in this contempt petition, is it required?
Time for the petitioner to file supplementary affidavit in terms of our order dated July 17, 2023, is extended by a week from date. Tarikta দিয়ে দাও এক সপ্তাহ পরে তারিখ মানে 10 তারিখ August 10. Stop. Paragraph. Now, from date stop. Let an advance copy of the affidavit be made available to learned advocate for the appearing respondents. Stop. Paragraph. List the matter once again on August 14.
14. Grateful. Chalo, 14 bolo to.
Next matter should also come on 14th.
Lordship, may I pray for 10th for that?
Huh?
10th.
10th.
On the track repository, it is incomplete, my lord, that's why the affidavit of service could not be affirmed.
No, what do you want? Number 6, what do you want?
It can, it may, I'm praying for listing on 10th.
10th. 6 থেকে 10th করে তো অর্ডার দরকার নেই কিছু।
Lord, my opinion, Lord. If your Lordship remembers, Mr. Bose is leading me in the matter. It's the heritage property matter, my Lord. We had
Where is Mr.
concluded,
Bose?
my Lord, we had concluded our submission.
Yes, Mr. Alok Ghosh is supposed to make
Right.
submission. Pass it over once.
Mr. Alok Ghosh and Mr. Gopal Chandra Das is appearing on behalf of Kolkata Municipal.
Yesterday, Mr. Ghosh took a day's adjournment saying that today he will do it. We remember. So we are passing it over. See if he can do it today.
I'm informing.
Eight. Pass over. এই আরে আরে শোনো 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 8টা তো একটা রিট পিটিশন
কত কল করলো 8 না 9 8
8 is a writ petition. Why is it before us?
This is with regard to the heritage matter. Lordship is hearing the division, the appeal. That is why they are come up before Lordship in an appeal.
Oh,
Lordship said this will be tagged along with
দেখিয়েছিলেন হ্যাঁ very well, very well. Pass it over.
This is a heritage matter, my lord, challenging the propriety of the order dated 21st of June 2022, passed by my lord Justice Sinha, my lord. The Kolkata Municipal Corporation preferred this appeal,
Yes.
and subsequently, my lord, one hearing was there, and subsequently I have been briefed. Initially, this matter was in the, my lord, the division bench, and subsequently, your lordship was pleased to, my lord, release the matter and to commit in the regular bench, and therefore this matter is appearing in the regular bench, my lord.
Yes. So we'll hear it.
But I'm paying for a short passover.
Pass over.
My lord, in that event, make it not to even other matter is fixed in that event. If you, my lord, I think that they are not, my lord, not in a position to do the matter.
I'm waiting for Mr. Ghosh. My lord, item number 6,
He was
7,
there,
8.
he was there.
He was there in the
He
morning.
was there. in the
Item
morning.
number 6, 7, 8, all these are that heritage matter, my lord. Whether, my lord, the gradation, the list that we have made is in accordance with law, and Lordship was hearing the matter other day. So, my lord, Mr. Ghosh was supposed to make
Your
argument
lordship pleases to
the
fix
item
any
number
date.
6. So, my lord, I made a phone call with him. He's in court number 24.
Look, Mr. Dattu, let
Somehow
Mr.
he
Ghosh
got
come.
started.
If you are not there, we'll not take up this matter.
Mile.
Pass it over. Pass it over.
Great.
You are for the writ petitioner. টেনেও কেউ নেই টেন হচ্ছে সেই যেটা অরিন্দম করছিল করো আবার ডাকো টু ছিল কেউ ফার্স্ট কলে
I just prayed for a short passover. He's doing a matter. Another
Who?
court, my lord. Mr. Raghunath Chakraborty is leading this matter.
How many Passovers will be there?
Well, in the matter. And it's an order against demolition.
You are not appearing in the matter.
I am appearing, but this is a
Appear. এই দেখি দাও ফাইল দাও হ্যাঁ, এটা দেখি।
Order at page 88, Lordship.
But we have raised a construction. Admittedly, there was some unauthorized construction. And we made a representation for regularization of the same. Some person,
Allow us to go through the orders, sir. Allow us. That's it.
That salah. Na. And the similar sort of matter, your lordship passed this order, this sort of.
Let us see the order once.
Lordship. Lordship. Here 5 stories illegal, here 2 stories illegal admitted.
Actor. This is a division bench, Mr. Das.
Your lordship's order. I am extremely sorry, my lord, last moment. I am extremely sorry. I may be excused, your lordship. I may be excused, your lordship. Only one copy, my lord, hurriedly. I am sorry. I may be excused.
It is without any sanction.
That is,
He is telling that he is.
the 2-story there, that is admitted condition.
We have a sanction for a
The observation by your lordship in the page 3 is regarding this sort of practice coming before this court for regulation and other things. Very clearly.
There is a circular from KMC that.
My lord, that is that.
10 meter, 25 meters with.
My lord,
regularization fees.
my lord, here the case is this. When that is unauthorized construction detected,
I'm asking this question too, that there is a circular from KMC or something like that.
lordship,
That 10 meters height, 25 meters, this fees has to be given, deposited for retention,
for retention, that
Yes,
matter.
10 meters, 25 meters.
My lord,
25 meters means, that means almost 3 stories.
my lord, that part is there, but the only thing is 401 and 8, he is in the, that is the premature in the sense, 408 has never been, till date not taken, not taken.
Without any sanction, not a single step of it.
Only thing is person intentionally constructed and thereafter file that observation in the landed single judge order that 3 days, within 3 days, regulation application filed and come. Right.
কবে করেছে? 23শে জুলাই রেগুলেশন প্রেয়ার করে 24শে জুলাই রিট করেছে। হ্যাঁ, এই আমার এইটা একেবারেই বোনাফাইডই নয়। Very bad case, Mr. Chakraborty.
Lordship?
Very bad case.
No, my lord, the only thing is, my lord,
We doubt your client's bona fide is also 23rd July, the application made for regularization and 24th July, the writ petition filed.
no, at the same time, my lord, maybe, my lord, we have applied before the authority, my lord, to look into the issue in terms of section 400 subsection 1. Here, my lord, I'm showing, my lord, kindly see. On page 67, my lord,
Mr. Das, preside the application within 1 week. Regularization, reject it if you like, reject it. Reject it, then break the, demolish the structure.
That's indication.
Yes, yes. Now that they have made, we see nothing wrong with the learned single judge's order. Absolutely. But we'll only say since an application has been made, good, bad, indifferent, let it be decided in accordance with law after giving an opportunity of hearing. And if it is allowed, then naturally no question of demolition. If it is not allowed, go ahead with the demolition. Have you followed what we have said?
Only clarification from your lordship.
Yes. Yes, Mr. Chakraborty, this is the most we can.
my lord, we are natural justice to be complied. This is my
This is the most we can do.
most important prayer. My yes, my lord.
We have said so after
Yes,
hearing.
yes, my lord, yes.
না না এটা ফেরত দিয়ে দাও আমরা রেফারি করবো
Now,
There is a demolition order.
My lord, some person visited my premises. My lord, they requested or rather directed us to vacate the premises.
Without serving any order.
No, my lord, because of their it is under section 400 subsection 8.
Oh, a
That
subsequent.
is the whole detail, my lord. Otherwise, issues given to us, and we will give an opportunity, we shall make our case before the appropriate authority and final decision to be taken by the appropriate. We are saying that, my lord. Let me
You have a sanction for ground plus
Yes, my
one.
lord, yes, my lord.
Ground plus?
3.
You have a sanction for ground plus.
It's a Thika property, lordship. My lord, I am not justifying my stand. Lordship knows, my lord, tenants are required to be accommodated, my lord. That
Issue.
being
Issue.
page 68, my plan, my lord.
A judgment and order dated July 24, 2023, whereby the appellant's writ petition being WPO number 1433 of 2023 was dismissed by a learned single judge of this court, is the subject matter of challenge in this appeal. Paragraph. It appears that the appellant oblique writ petitioner obtained sanction of a plan from Kolkata Municipal Corporation for raising raising a 3-storied residential building. Stop. It further appears that the appellant and other co-tenants constructed 2 additional floors in deviation from the sanctioned plan. Stop work notice was issued.
Not stop work is issued, my lord.
That has been recorded by the learned judge.
Yes, my lord, page 83, by way of a supplementary affidavit, I have submitted it, my lord.
Stop. KMC issued stop work notice and thereafter initiated steps for dealing with the unauthorized portion of the construction. Stop. The appellant, on July 17, 2023, made an application for regularization of the unauthorized portion of the construction. Stop. Paragraph. It appears that people from the corporation, capital C, visited the property in question and asked the appellant and other tenants to remove the unauthorized portion. Stop. At this stage, the appellant approached the learned single judge with the instant writ application. Paragraph. The learned judge observed that there is no law which supports the contention of the writ petitioner that a construction made without obtaining prior sanction from the sanctioning authority, may be regularized subsequently. Stop. The learned judge also observed that the application for regularization was made on July 17, 2023, and apprehending initiation of demolition proceedings, the writ petition was affirmed on July 19, 2023, and the writ petition does not appear to be a bona fide one. Stop. With the aforesaid observations, the learned judge dismissed the writ petition. Stop. Hence this appeal. Paragraph. We have heard learned counsel for the petitioners, for the parties. Stop. Apparently, we find no infirmity in the order under appeal. Stop. However, comma, since the third proviso to section 400 bracket 1 has been introduced in the KMC Act and relevant rules have been framed in 2015, correct?
Page 72.
Comma. It may not harm anybody if the corporation first takes a decision on the appellant's application for regularization before proceeding to demolish the unauthorized portion. Stop. Paragraph. Accordingly, we direct the commissioner.
No, my lord, that is the special officer building also.
Special officer
building is there, also the executive engineer can be. Because that is 40 as per section.
Whom will we direct?
My lord, executive engineer, he is
No,
the
my lord,
respondent here.
Special officer is functioning, discharging
My
the
lord,
duty
copy
of.
is given to the executive engineer also, this application.
So, my lord, the same person, if it is relegated to the same person, our apprehension is, my lord, he will consider,
The
My-
competent officer.
my lord, the municipal
the
commissioner
competent
or his delegate, municipal commissioner or his delegate.
Or his delegate.
Let it decide.
Or is there, my lord, the competent officer of the KMC who is authorized by the law?
We'll say the competent officer.
That I.
We direct the competent officer in KMC to take a reasoned decision on the appellant's application for regularization of the impugned structure, comma, in accordance with law and the applicable rules, stop, a comma, within a period of 2 weeks.
2 weeks.
2 weeks from the date of communication of this order to the competent officer, comma, after granting an opportunity of hearing to the appellant or his authorized representative, stop. Needless to say, comma, if the appellant's application for regularization is allowed, comma, the question of demolition may not arise, stop. However, comma, if such application is rejected by the competent officer, comma, KMC shall proceed to demolish the structure, impugned structure in accordance with law. Paragraph, we clarify that we have not gone into the merits of the case at all. Stop. We are not binding the hands of the competent officer in KMC to decide the appellant's application in any particular manner. Stop. He will decide the application in accordance with the relevant rules. Stop. That is all.
Yes, my lord, the relevant amended provision of the rule and extant regulation.
Already, lordship.
Rules and regulations.
And competent authority not made party, my lord, municipal commissioner may kindly be directed. He is at his liberty to
KMC is a
delegate.
party. KMC is a
My lord,
party.
He is at his liberty to
My lord,
delegate it.
My lord,
He may delegate.
here the difficult.
Sir,
My lord, if a decision taken by the,
we'll say better. This is vague.
yes, my lord,
তাহলে ওখানে competent officer না বলে বলো the municipal commissioner
lords,
or his delegate.
delegate.
হ্যাঁ সব জায়গাতেই ওইটা করে দেবে। হ্যাঁ
And I'm not standing on the way. 2 weeks is very little time for Kolkata Municipal Corporation.
They
to
say
send
they
us
can
notice,
do
my
it. They say they can do it. Let them do it.
No, well, make it 3 weeks. This is Chakravarti is very.
No, no, I am not worried. It is not my tension.
3 weeks.
It is
further.
their tension.
Make it 3 weeks.
I know them, my lord.
Since we have not called for affidavit, etc., etc. আচ্ছা order that is single judge set aside.
Yes, deep.
Item number 7.
There
There is a Purti matter, my lord. That is.
Which one? So, দেখাচ্ছে তো 2. Yes, where's Mr. Ghosh, Mr. Dash?
Sir, Ghosh is engaged in another court, my lord. Due to Mr. Ghosh is supposed to argue. On
Yes.
that occasion, my lord, I am praying
Yesterday he told us he'll argue today.
today. My lord, only not today, then, my lord, no order.
Not today, what can be done?
My lord, I am sorry, my lord.
Will your lordship be pleased to take it tomorrow? Monday.
Next,
My lord, could it be on Monday, my lord? Tomorrow,
Only Monday.
deeply obliged.
1 day's accommodation is sought for on behalf of Kolkata Municipal Corporation. Stop. Paragraph, learned advocate for the appellant requests the matter to be listed again on August 7. Stop. Let that be done.
Deeply.
Mm.
Item number 8. This is connected with the earlier matter, so let this also stand over, my lord, till 7.
It will just simply adjourn till Monday. You are for the petitioner.
I am for the petitioner. This is that writ petition which was called.
I know, I remember. I was rather hoping that nobody will be there, 2020 writ petition, second call, and I will dismiss it.
I'll surprise you.
Yes.
In a similar appeal, my lord, it was dismissed for default in the second call. But then that was ultimately, that had by that time been settled between the private respondent and the appellant. And therefore, my lord, I did not make any prayer, my lord, for your lordship to recall the order before signing.
Yes, yes.
Lordship,
Give us the name of the case.
But I'm bad at names, I forget.
I remember because when we dismissed it for default, I told my brother, within 2 days, Mr. Banerjee will come with a restoration application.
But then that was, by that time, that had already been settled.
Good.
The only prayer which I would have made was for dismissal for withdrawal instead of default. The parties decided not to bother your lordships.
Now, 9 is again that heritage matter, my appeal. So let this also be kept on Monday, subject to your lordship's consideration.
Monday. 10, Mr. Bishoj.
10,
Mr. Mukherjee was arguing.
Yes, he was arguing.
কি রে বাবা আজকে কি হলো? Not today or what about tomorrow? Monday.
Monday.
You are appearing?
I'm led by Mr. Vishnu Mukherjee.
Yes.
He's on the leg. Make it Passover or not today, my lord?
Passover. This is the last only matter remaining.
Then
You're briefed in the matter.
no, my lord.
You are Miss Odhikari.
No,
No, sorry.
I'm Komal Shah, not Chamber Junior, not even came.
You're not briefed.
No, my lord.
Monday. Tomorrow, second half, this bench is a little uncertain. Therefore, we are not.
Tomorrow we Monday. Yeah, Monday.
Time there.
Let's sign item number 3.
Your Lordship, I appear on behalf of the appellants.
Yes, Baba.
Your Lordship, on earlier occasion, the respondent number 3 and 4 submitted that the advocate Mr. Sandeep Bhattacharya, who is appearing for respondent number 3 and 4, was ill. So he was hospitalized. Your Lordship directed the matter to be adjourned for 3 weeks. But Your Lordship, in the order sheet, it was inadvertently recorded as the advocate for the appellants, Your Lordship. It would be advocates for the respondent, Your Lordship. Respondent number 3 and 4.
You are Mr. Dotto?
No.
You are Mr. Dotto? No.
No.
What is your name?
Shaunak Sen, Your Lordship. I am led by Mr. Subroto Kumar Basu.
Okay. Let the order dated July 28, 2023 be corrected by substituting
Led by Mr. Nayak.
substituting the word appellants within inverted comma by upper inverted comma respondent numbers 3 and 4. So let the correction be incorporated in the order dated.
Item number 4.
কিছুই নেই।
করেছে বলে কেউ নেই নাকি?
না, কেউ নেই স্যার।
করেছে বলে কেউ নেই।
Yes, Mr. Basu. Number 4.
Election Commission is there.
You are for the
I am for the applicant leave to appeal and stay and appeal.
Election Commission, Your Lordship.
The read petition is not here, state is not here.
Passover, usual Passover.
5.
Same.
Item number 6.
6, I am appearing on behalf of the private respondent.
6.
There were 3 issues in my read application.
6.
3 issues. Item number 6. 6 though. Item 6. Item 6.
6. You are for?
I am for the appellate.
You are for?
Private respondent.
State is not here. Any other official respondent is there?
Okay.
Any other official respondent is there apart from state?
No.
Municipality.
Municipality is there. Yes.
Then why are you saying no?
Sorry, sir.
Pass over, Mr. Ali. In the first call, unless all parties are there, we pass it over.
Uluberia municipality.
In the second call, if service is complete, we take it up irrespective of which party appears or not.
And in case I am absent, my lord, your lord.
We will make it not today. In the first call, if the appellant is represented, then in the second call, it is not dismissed.
That's a privilege. My lord. The privilege.
Item number 7.
So not today. Pass call a Passover. Again, wait for it.
Item number 8.
Well, in this matter, my lord, we are appearing on behalf of the appellant applicant.
Appellant 8.
8.
Pass it over. None of the other parties are here.
But municipality is there and my lord, private respondent is also there.
Pass it over. The second call, we'll take it
May
up.
I pray before your lordship, can you take it up tomorrow?
To take it up tomorrow.
Well.
Very well. Not today.
I'm the
Item 9.
My lord, item number 9 and 10, my lord.
Asking you first for it.
Item number 9 and 10, my lord, I tried to communicate my client several times for last 1 month, my lord. He is not responding. My lord, I need to write a letter to him to respond, my lord. Kindly give me a 1 week time so that I can take instructions from him.
You have no merit at all in the case.
My lord, there are merits, my lord.
On the prayer made on behalf of the appellant, comma, let this matter stand adjourned and be listed again on next Thursday করে দাও ডেটটা দিয়ে দাও same order in 9 and 10. If by next Thursday you can't contact, come back and tell us. We will grant you leave to retire and dismiss the appeal.
Great. Great.
This was made returnable, my lord, for the purpose of filing of
For register lordship, that fishing boat matter.
for
For
filing,
filing
of
written note.
notes, just for the
Filing
written notes. No one is appearing. My written notes are, my lord, ready. but
The
no one
appellant is not here.
Appellant, my lord,
You are for the bank.
I am for the, no, I am for the register lordship, registrar. We have no function practically because
You need not file any note. The bank needs to file and the appellant needs to file. We'll take your note on record
second call, my lord.
and keep it on Monday.
Very lordship,
tomorrow.
I'll pass it over.
Okay, we will pass it over.
Very good. I'll try and contact Mr. Bahari.
better Monday take it up. Monday rakho, they will let them come. No, better lordship, let it fix up Monday because they are not present.
As
May
your
not be.
Monday.
Lordship. Right there.
But well, your money is kindly make it 1 day's accommodation, my lord. Mr. Manna is appearing in this matter, my lord. Ashit, sir. Well.
Okay, 11. No, but bank is not here.
Kindly take it up, please.
Oh, your note is not ready.
Ready, I have.
Tuesday. 11টা Tuesday, 11টা Tuesday. Yes, 12.
Not 12, kindly make it 1 day's accommodation. Mr. Manna is appearing, my lord. He's out of court, my lord.
Not this
Not
week.
today. Not today, my lord.
Not
Only.
today.
Great, my lord.
Oh, এটা record করো on the prayer made on behalf of the appellant. Let this matter stand adjourned for the day.
Great, my lord.
Item 13. We call item number 4.
Every service day.
Affidavit of service.
Yeah, that is fast. That panchayat elections matters. My point is before my lord, I am the elected candidate. I have been not made parties in the proceeding. The Honorable single judge entertained the proceeding, directed the respondent to consider their case. I say 2 things. First of all, my lord, without hearing me, this order could not have been passed. Again, my lord, in view of 243O, the only election petition is maintainable, nothing else. Because the disputes ought to be raised that boot was captured. This requires an evidence to be adduced. The authority, my lord, it is a futile exercise. I am not party. That's why I filed.
In the appeal.
Yes, election commission, state and the writ petitioner.
Election commission is here.
Yeah.
State is not here.
State is not.
State, how have you served? Whom have you served?
কিভাবে সার্ভিস করেছিস? I have not checked up personally. কোথায়? দেখে বল না। অরিজিনালটা কোথায়? দিয়েছিস? Yes, yes. Writ petition has been served personally. Justice, government pleader served personally.
GP's office.
Yes.
Very highly ineffective service. We have seen from our experience, you serve on the GP's office, obtain a receipt, and then nobody appears.
That.
No, this, I think something has to be done. We are not saying you are at fault.
No,
We are
no,
not saying so.
I'm not quarreling with the judge. What I'm saying, my lord, once it happened, I serve all the parties. After serving, I intend to move. None appeared. Honorable just said you have to serve the GP. Well, why? I have served all the parties. If I am not serving the parties and extreme urgent application has to be moved, then the GP can be served. A GP is,
Let us see the order once.
yes, my lord, can you see the order? Pick up the-
And read petitioner, how have you served?
My lord, read petitioner by personal service, advocate record has been served.
No, Mr. Basu. That may not
Accepted
be
service.
proper. That may not be proper.
Landed advocate record accepted service. No, satisfaction is my lord, but we have served on the landed advocate record who filed the writ petition. আমারই তো স্যার এখন সকালে দিয়ে লাভ দেখি আমাকে এখন যেতে কোনো লাভ নেই আমি দেখবো না কোনো সময় না সকালে দিয়েছো এতে কোনো রিজনিং নেই এতে কোনো রিজনিং নেই
Mr. Basu, what we propose to do then, we'll send it back, keeping the issue of maintainability open. Argue that before her ladyship. 243O, etc., etc. The Supreme Court decisions.
here also it can be done it's a question of law only no affidavit necessary
Because you see, recently in one of the matters, Mr. Anjan Bhattacharya was moving. We have thrown out on the ground of non-maintainability.
that's why my lord it will be easier
Oh, but
no had it been a my lord in a factual aspect affidavit this that I could have easily my lord I considered to that they had
particularly
seen.
because the writ petitioner is not here.
No. Leave, grant me leave today, add me, and let them come tomorrow, any day, but
No,
don't delegate me.
Go.
Don't delegate me.
Why?
I will not argue anything on facts.
No, go. Why do you want to burden us?
I will not argue anything on facts.
Go.
And the writ petitioner is not here on that ground, my lord, it has to be on the next date. No, nothing, no reasoning is there, nothing is there. In normal course, my lord, when a lordship directed any matter to consider, that has been done, but the consideration result will be futile.
Issue.
My lord is delegating me. I could have happy to argue before my lord this no fact necessary.
So go.
And I've been told, my lord, I have not seen the judgment. My lord has decided that point.
Show that to the learned single judge. From the affidavit of service filed in court today,
You're dictating your senior.
it appears
Assisting.
that learned advocate on record for the writ petitioners have been served. Stop. However, the writ petitioners are not represented. Oh, na, shuno. এর আগে তুমি এটা নয় can যেটা leave to appeal. Which can is that?
Leave to appeal कौन क्या आना चाहिए?
Leave to appeal কোনটা রে?
Can one.
Can one মানে leave to appeal.
One টা নিয়ে লেখো. This is an application for leave to prefer appeal against a judgment and order dated
24th July.
July 24, 2023, whereby WPA 16742 of 2023 filed by the respondent numbers 1 and 2 herein. They are the respondent numbers 1 and 2 herein was disposed of by a learned single judge of this court. Stop. The intending appellant is was not made a party to the writ petition. Stop. Paragraph. Mr. Basu, learned senior advocate appearing for the applicant, says that the applicant is the successful candidate. Stop. Without hearing her, no order should have been passed by the learned judge. Stop. Paragraph. We are of the view that the applicant may have something to say about the impugned order. Stop. Hence, leave is granted to prefer appeal against the impugned order. Stop. Can one is disposed of. এবারে ওই অন্য ক্যানটা আর ম্যাটটা নাও।
Allow হয়ে গেল।
From the affidavit of service filed in court today, it appears that state, you are the state.
For the state. বাস ঠিক আছে।
Thank you very much.
বাস আর কিছু বলতে হবে না।
Thank you very much for appearing.
বাস বাস।
Yes, what is your instruction?
আবার গন্ডগোল।
The husband of the not made a party, that's all.
We are sending it back to the learned single judge. Affidavit service filed in court today. All the respondents have been served. Stop. The election commission and the state are represented. Stop. The writ petitioners are not represented. Paragraph. The writ petitioners approached the learned single judge alleging that the husband of the returned candidate, comma, i.e. the present appellant, comma, is a member of the police force and he was responsible for manipulating the votes. Stop. It was alleged that booth capturing took place. Stop. It was submitted that a representation had been made before the State Election Commission, but the same has not received the attention of the commission. Paragraph. The learned judge disposed of the writ application with the following directions.
Kindly, if possible, kindly, my point maybe.
Yes, we are just, of course, we'll, your point meaning?
243O, 243O.
Yes, yes.
Kindly indicate that.
Yes.
May I only one thing for you? I am for the lead petitioner and the single means I believe it's.
We can't hear you.
জোরে বল এনে।
Your Lordship, I am led by Mr. Sobosai Chatterjee. I am for the writ petitioner respondent. Mr. Chatterjee is on his legs. Kindly give short password.
Sorry, we are dictating the order, sir. You are very late in coming. You should have come and sought adjournment at the very beginning. Second call, we have dictated half of the order. Sorry.
4 and 5 item number, both.
এই তোমার লিভ অ্যাপ্লিকেশনটার পেজ 11 Huh? Next, being aggrieved, comma, the successful candidate has come up by way of this appeal. Paragraph Mr. Basu, comma, learned senior advocate appearing for the appellant says that the appellant was a necessary party to the writ petition. Stop. She was not impleaded. Stop. In any event, comma, the writ petition is not maintainable in view of the constitutional bar in Article 243-O of the Constitution, read with the relevant provisions of the West Bengal Panchayat Election Act 1979. So, Mr. Basu also wanted to refer to decisions of the Honorable Supreme Court in support of his case. Stop. Paragraph, we are not
Lordship, it was
inclined.
only served day before yesterday. Lordship, there was no indication that it will be taken up today.
What do you say?
I
was-
have to reply to this, Lordship.
He has not been added as a party. We are remanding it. Yes. Why did you not add? Then this appeal would have not have happened. Of course, she's an. Oh, then, of course, then you're all right. What would happen to the profession?
They should have been.
Kyolo? To enter into the merits of the case. Stop. However, comma, we are of the considered view that the appellant herein is a necessary party to the writ petition and justifiably may demand an audience before the writ petition is disposed of. Paragraph, accordingly, only on the aforesaid ground, comma, we set aside the order under appeal and remand the matter to the learned single judge having determination to hear the writ petition, keeping open all points, including the point of maintainability of the writ petition. That is all. Paragraph, since we have not called for affidavits, etc., etc., etc. This is even better for the profession.
That's why Malot said, why you have not made party? I am opposing
No,
that.
that's why I'm in that score. I'm not opposing to his parents.
Acta add করে দাও. We request the learned single judge to dispose of the writ petition by passing a fresh order after granting an opportunity of hearing to the present appellant.
Let them make it as a party.
Stop. Mr. Chatterjee, comma, learned advocate appearing for the writ petitioners says that his clients shall add the present appellant as a party respondent in the writ petition.
Item number 5.
My
Lordship, its appeal is not maintainable because this is by the husband of the candidate.
The complaint was kindly see the allegations.
Yes, not been made part.
Actually, there is an allegation that this person is influential because this is not. I'm raising an issue of maintainability. So
Let us see the order once.
Yes.
Well, the same order is as in item number 4.
Same order.
What has happened, my lord, I am the husband of the elected candidate. I am serving on duty with the Bagnan MLA as a bodyguard. My lord. Allegations has been leveled against me in the representation and not made a party. My lord. I have nothing to do with the election, nothing. They have filed a writ petition on a
Mr.
separate.
Chatterjee, the representation contains allegations against him.
Is it a necessary party in a petition?
According to us, yes.
So Lordship, I beg to say
Because if we grant him an audience, he would get an opportunity of at least persuading the judge. Whether he will succeed or not, we don't know. Opportunity of persuading the judge that this is not a fit case where even consideration of representation should be directed.
Lordship, may I say this? Lordship may hold it that he will have the right to audience there, but without making him in the party. Because
That
so
can't-
far this, my submission, humble submission, Lordship, this is the dispute related to the election. I understand the client of Mr. Basu is a necessary party for this. On that score, your Lordship has set aside that order and remanded it back for the fresh consideration of the learned judge. Now, this is a ground that her husband has influenced the entire system to get the vote. It is undue influence, maybe, if I term it. In that
Mr.
score,
Chatterjee, what
Lordship,
is the difference? It is identical order in the previous case also. The allegation was that the petitioner's husband is in the police force
Yes.
and indulged in booth capturing. Same allegation here.
now, so far the petitioner's husband is concerned, Lordship, he is neither a contesting candidate or election agent.
To prevent the conflicting decisions,
Oh.
we have to send this
It
back.
has to be the same order.
To prevent
It's
the-
identical facts. Identical facts.
But-
Same order.
But so far the appellant is concerned, Lordship, they are not the same.
My lord, kindly record
same
that, my lord, the
status is
appellant
not
is
there,
not
that
the
is-
contest winning candidate over here. In
Appellant?
item number 5,
Yes.
the appellant is
Is
the
not the-
husband of the winning candidate. My lord, in the
Husband
last-
of the
husband of the winning candidate in item number 4.
4. That is the thing, Lordship. That's why I'm.
in 5.
5
Appellant
has been
is who?
filed by my lord.
5 is the husband of the appellant in 4.
Yes, my lord.
That is why I'm raising this issue.
How is he concerned?
Kindly takes up the representation at page 47. All the allegations has been leveled against me. Who am I? I have nothing to do. And a separate writ petition has been filed. Kindly see the averments in the writ petition. my lord. In the, they have stated that there is.
You are
a
a member of the police force.
Yes.
Dr. Sarfaraz Mullah.
No. Kindly
Taibur.
takes up page 47.
Oh, Taibur Rahman.
Taibur Rahman.
Taibur Rahman.
My allegation is that that person is the bodyguard of the local MLA.
No, his wife is the successful candidate.
Yes.
Successful candidate, his wife.
Your wife.
My wife.
Appellant in item number 4.
Stronger case. Because allegations are directly against him. Yes. Issue. We again leave application.
Can 1 is the leave application.
Now, can one to now? This is an application for leave to prefer appeal against the judgment and order dated July 24, 2023, whereby, and the writ petitioners are respondent numbers
1 and 2.
1 and 2. কি বললাম? Writ petition. The writ petition of the respondent numbers 1 and 2 herein, being WPA 16742 of 2023, was disposed of. Stop. Paragraph. The applicant says that he is the husband of the successful candidate. Stop. The allegations in the representation which the learned single judge has directed the authorities to consider, are all against him. Stop. He should have been made a party to the writ petition and should have been heard before the writ petition was disposed of. Stop. Paragraph. Having heard learned counsel for the parties, we are of the view that the applicant has locus standi to maintain this appeal. Stop. Accordingly, the application is allowed. Paragraph. Paragraph now. Itapur unno can or eta now. The writ petitioners approached the learned single judge alleging that the appellant, a member of the police force, was responsible for manipulating votes. Stop. Several allegations were made against the appellant, including booth capturing.
Was a member of the police force as well as posted as the bodyguard of the local MLA.
Very well.
as well
under
as
the local
police
police
force,
station.
and was posted as the bodyguard of the local MLA. Stop. It was submitted that a representation had been made before the State Election Commission, comma, but the same had not received the attention of the commission. Stop. Paragraph. The learned judge disposed of the writ petition with the following directions. With page 11 leave application, mark করে দিচ্ছি। Paragraph. We are of the view, having heard learned counsel for the party. Let's set out kore next. Being aggrieved, comma, the present appellant has come up before us. Paragraph. It is submitted on behalf of the appellant that since the allegations are directed against him, comma, he should have been included as a party to the writ petition. Stop. He should have been heard before the writ petition was disposed of, comma, albeit, albeit, albeit for consideration of the representation of the writ petitioners. Stop. Paragraph. We are inclined to agree with the appellant. Stop. Since the allegations and complaints made by the writ petitioners are against the present appellant, comma, we are of the opinion that the appellant should be granted an opportunity of hearing before any order is passed on the writ application. Paragraph. Paragraph. On the above ground alone and not entering into the merits of the case at all, comma, we set aside the order under appeal and remand the matter to the learned judge having determination to hear the writ petition. Stop. We request the, we add the appellant as a party respondent to the writ petition. Stop. Learned advocate on record for the writ petitioners shall carry out necessary amendment to the cause title of the writ petition. Stop. We request the learned single judge to decide the writ petition afresh after granting an opportunity of hearing to the appellant hearing.
Well, the point of maintainability is to be kept open.
Stop. We leave all points open, including the point of maintainability of the writ petition.
Grateful.
No, Lordship, one thing, since he is not a party in that dispute, maybe he may be permitted to only demonstrate his case, that allegation against him, because maintainability point will not be raised by him.
Now that he is a party?
Now, Lordship, the question is that, that's why I was indicating, Lordship, that whether he is a
Mr.
necessary
Chatterjee, let the law be settled. The law is still in a state of flux.
That's why Lordship is not a even regarding the election petitions.
Come up again. You'll come up again before us. Any of you will come up.
We'll have to, because Lordship, the election petition within 6 months, futile exercise. No
Let
one
us see.
will be able to do it.
That will not be affidavits not invited, etc., etc. He will be.
Item number 6.
My lord, I am aggrieved. I am aggrieved, my lord, by the order dated 12th May 2023 passed by the learned single judge.
All parties have been served.
Yes.
Private respondent is not represented. You are private respondent. State,
State and
municipality.
Ulubedia municipality.
Municipality.
Private respondent.
State হয়ে গেছে।
সবাইকে স্যার বোঝায় নাম লিখে দেয়।
আর কাকে দেখবো স্টেট ফোল্ডে আর কাকে
Chairman Ulubedia. Yes, Mr. Ali.
Yes. Well, the order I am aggrieved of, your lordship will kindly find in the memorandum of appeal. Order dated 12th May 2023. A report has been filed by the Block Land and Land Reforms Officer, which mentions that a field inquiry was conducted in the presence of the representative of municipality, petitioner and the private respondent number 8 and others. Upon inspection, it revealed that there is no encroachment of the public road. That was one of my complaints. A report of the municipality is also on the same line. There is no encroachment of the public road. As it appears that the petitioner complains of encroachment and there is a report from the BLLRO, there is no encroachment on the public road. Accordingly, the allegation of the petitioner remains unsubstantiated. It will be open to the petitioner to appropriate forum in the event any private land of the petitioner has been encroached upon. The last part of the order, yes, but that was one of my grievances. But the other grievances, your lordship will kindly come to page 20 of the stay application of the application for interim order, page 20, which is the prayer of my prayers in the writ application. Direction and or order should not be issued commanding the respondent number 2, 3, 4, 5, 6, and 7 to perform their statutory duty to demolish the unauthorized construction made by the respondent number 8 on the shallow land. That means without conversion, agricultural land is being used as a homestead land, and the municipality grants a permission, gives a sanction. Can it be given?
Have you made any representation to the municipality?
I did. Not once.
No.
Police gave information.
No response.
No. But that is about the municipality. But I am on appeal. I am on appeal against an order passed by the learned single judge. Was that an only issue in my writ application? Because that some inquiry has been made, it might be an administrative inquiry. But it is not a judicial inquiry.
Encroachment on your land, we understand.
Yes.
That will be a private dispute. You have to go to a civil forum. Encroachment on public land.
Yes.
That the BLLRO says there is no encroachment.
That may be, but BLLRO might have been saying it is an administrative inquiry. But I say, my lord, that the measurement has to be made because the report is
Insofar as unauthorized construction is concerned, we can definitely direct the municipality.
That is one.
Yes.
My lord, I'll be very obliged, my lord. But your lordship will kindly take up with regard to the encroachment of the public land. With regard to the encroachment of the public land. Lordship kindly takes up my memorandum of appeal and the ground I have taken, whether it has been reflected in the inquiry report. My lord, ground 5. Ground 5. The learned judge followed a summary procedure to adjudicate questions of facts as well as of law, as made out in the written, not in judicial procedure of review, but in a manner of in a manner commensurate with an administrative inquiry. I am before the court of law. I am not dependent upon the BLLRO. Well, it is for the purpose of getting elucidating the fact. But the question of law remains. Question of law remains with regard to the review of a writ application where my grievances are different. On all issues, my lord, the court has to consider this issue. I am not before a Khap Panchayat. I am before a writ court.
So what according to you the learned judge should have done?
My lord, for that the learned judge made a scrutiny, had the learned judge made a scrutiny of the inspection report of the revenue inspector, it would have been clear that the exact position of the private road could not be ascertained. Such confused state of issue was not addressed by the learned judge. Arriving at a definite conclusion, the allegation of the petitioner remains unsubstantiated. And even the
Such confused state of the issue was not addressed by the learned judge.
Yes.
How the judge will get
My lord.
confusion? How it can be
My lord, if there are two, my lord, conflicting reports, that in that conflicting report has to be sorted out. My lord, it is for the learned judge to decide. And if the learned judge wants to rely upon a particular,
These are factual disputes.
if upon a particular factual aspect,
It requires evidence.
that's right, it is a factual dispute. My lord, if the factual dispute, so there are two contradictory things. In that event, my lord, the one which is being relied upon has to be relied upon by giving a particular reason. Is it there? No reason. And the next one, my lord, the measurement of the land is also in dispute. Measurement of the road. The measurement of public road as reported by the revenue inspector in our report. There also the report is there. So therefore, my lord, the first question is that on a Shali land, the municipality grants and sanctions for a building permission. No. One. The second is the road is there. That road has not been measured. The measurement of the road, that is also contradictory. So, my lord, it is the municipality. The municipality can take actually the report, my lord, as to whether permission was rightfully granted. And the road, one of the private dispute, I am not impressed.
Have you submitted any Porcha, RSROR or something like that so that we can understand that the land is Sali?
Mr. Yes.
Land is Sali. You are
Yeah.
telling. Is there any document to that effect that the land is?
Everything I have submitted.
What is that? What is that?
What's that? Recorded.
A record. Yes. Acha, acha.
Rama, may I,
Mr. Ali,
my lord,
in our opinion, the proper course of action, because there are factual disputes also,
yes,
will be to request your grant liberty to your client
yes,
to make a comprehensive representation to the municipality to be decided within a time frame by a reasoned order in accordance with law after granting opportunity of hearing to your client and the private respondent.
But till that, my lord, till that inquiry is completed. My lord, no construction will be made on that.
there is no
On the
construction.
Sali land.
Only my lord, boundary wall has.
Yes,
There is no construction.
yes.
No further construction.
Maybe.
For 4 weeks. You will be heard also.
Yes.
But,
4 weeks stay you has what you intend to construct.
but now I made an application for conversion and that has been allowed and in future may be constructed. But dispute regarding the only boundary wall, I never encroach any land.
Do you have a building plan, sanctioned building plan?
Construction hasn't been commenced till now. Only boundary, in the,
River is not construction.
We are asking, do you have a sanctioned building plan?
no,
So you will take some time to get that sanctioned building plan.
certainly.
Therefore, for 4 weeks, don't construct. This is all we are saying.
No, no, I have not constructed anything, only boundary wall has been that complete. That,
Okay, we will record your statement. That there is only boundary wall and there is no immediate plan of constructing anything.
Have you converted?
yes, this is already been conversion has been made, but that has been converted and construction has not been made. I never encroach any land, but all.
We will record your submission. Let the municipality decide this dispute.
But this, video.
Go there. We'll come back in 5 minutes.
Minor.
It's a walk we take
Minor.
on medical advice.
Minor.
You can leave if you want to.
No, I'll be here video. Yes.
This appeal is directed against a judgment and order dated May 12, 2023, whereby the appellant's writ petition being WPA 28944 of 2022 was disposed of by a learned single judge of this court. Paragraph. The appellant had approached the learned single judge with the grievance that the private respondent has made unauthorized construction encroaching on Shali land of the government. Stop. Neither conversion was obtained by the private respondent, nor building plan could be sanctioned by the concerned municipality since the land was public land. Stop. Paragraph. The learned judge called for a report from the concerned corner from the Block Land and Land Reforms Officer, Ulubedia, Roman 2. Stop. Such report dated April 28, 2023 was filed. Stop. It appeared from the report that a field inquiry had been conducted in the presence of the representatives of the Ulubedia municipality, the writ petitioner and the private respondent and others. Stop. Such inspection revealed that there was no encroachment on public road. Stop. A report that the concerned municipality had filed also was to the same effect. Paragraph. The learned judge accordingly held that the allegation of encroachment on public road by the private respondent, remains unsubstantiated. Stop. The learned judge disposed of the writ petition by granting liberty to the writ petitioner to approach the appropriate forum if any private land of the writ petitioner has been encroached upon by the private respondent. Private respondent, one or more?
More. Five.
Plural.
There is a 5, 6 and 7.
With a one only. Muzam Hussain Gori.
Not one.
One. Paragraph. Being aggrieved, the writ petitioner has come up by way of this appeal. Paragraph. Mr. Ali, learned senior advocate representing the appellant / writ petitioner, says that the learned judge ought not to have disposed of the writ petition by relying upon the report of the concerned BL and LRO. Stop. Certain fact-finding exercise has to be undertaken. Stop. Although disputed questions of fact are involved, the writ court is not altogether powerless to decide such questions. Paragraph. Learned advocate for the private respondent says that the allegations made by the appellant / writ petitioner are completely incorrect and baseless, Stop. Conversion of the land in question has been obtained by the private respondent. Stop. The private respondent has till date not made any construction on the concerned land. Stop. Only a boundary wall has been constructed. Stop. Paragraph. Having heard learned counsel for the parties, municipality is not present, na? No. From the affidavit of service filed in court today, it appears that all parties have been served, but the municipality is not represented. Uluberia municipality. But Uluberia municipality is not represented. Paragraph. Having heard learned counsel for the appearing parties, we are of the view that since disputed questions of fact are involved, it would be appropriate to direct the appellant oblique writ petitioner to ventilate his grievance before the municipality, which can undertake a fact-finding exercise more conveniently and efficiently than the writ court. Stop. We are conscious that the plenary power of the writ court extends even to considering disputed questions of fact, if the facts and circumstances of a particular case so warrant. Stop. However, generally speaking, the writ court refrains from undertaking such an exercise. Stop. Paragraph. Accordingly, we grant liberty to the appellant to make a comprehensive representation touching all his grievances to the chairman.
Yes, respondent number 2. Chairman or executive official of respondent number 4.
Who? To the chairman of the Uluberia municipality, within, you will make representation within 4 weeks.
In 2 weeks.
2 weeks. Within 2 weeks from date, stop, date, with a copy to the private respondent, stop. If such a representation is made within the time period prescribed, the chairman of the municipality or any responsible officer authorized by him, shall take a reasoned decision on such representation, in accordance with law, within a period of 8 weeks from the date of receipt of a copy of this order, along with a copy of the representation, after affording an opportunity of hearing to both the appellant and the private respondent or their authorized representatives. Stop. The decision so taken by the chairman or the authorized officer shall be communicated to the parties within a week from the date of the decision. Stop. If the chairman stroke authorized officer finds any finds that any of the parties has committed any illegality, appropriate steps will be taken to remedy the same in accordance with law. Paragraph. Mr. Ali, learned senior advocate, says that till a decision is taken by the municipality, the private respondent should be restrained from raising any construction on the disputed land in question. Stop. We do not pass any formal order. Stop. We only record the statement of learned advocate for the private respondent that no construction as has been made till date, excepting the boundary wall.
After leaving the rear space. Rear space.
No, we are saying, sir, 2 weeks for representation, 6 weeks for, 8 weeks for decision. So till decision is taken, don't make any construction. You will know. Advocate for the private respondent that no construction will be made, no further construction will be made till the representation of the appellant is decided by the municipality. Stop. We make it clear that if the representation is not made within 2 weeks, the municipality will not be under any obligation to decide the same, and the private respondent will also be at liberty to make any construction that he wishes. After obtaining sanctioned building plan from the municipality.
Only one thing. If within 8 weeks, the hearing would be concluded, but would not taken decision by the municipality. But there is on that ground, the time framed by your lordship, that will be essential.
The time period paragraph. The time period prescribed for disposal of the representation of the appellant by the municipality, if such representation is made, is peremptory and has to be strictly adhered to.
Grateful, lordship.
Paragraph, since we have not called for, etc., etc.
Number 7.
No, my lord, I am appearing in this matter on behalf of state respondents. Now, my lord, before taking up this matter, your lordship has been pleased to inquire about fixing a date regarding that Baharampur municipality matter, my lord, today somebody has mentioned. So, my lord, subject to convenience of your lordships, my lord, it may be taken up on 22nd of August at 2 p.m. If your lordship is at convenience, my lord. No, we can. My lord, I will
Please inform all concerned advocates.
I will
Ready or?
Yes, absolutely. My lord, the law on constitutional tort, my lord, really, my lord, the parent judgment is on that.
Briefly the background.
Yes, my lord, this is that matter, my lord, where, my lord, the petitioner's predecessor had, my lord, purchased a property. There's a registered deed of conveyance.
Your writ petition has been dismissed.
Yes. By giving me liberty to approach, my lord, the municipality for compensation.
Oh, okay.
I'm sorry.
Oh, medicine shop.
Yes.
Oh, no proceeding, nothing.
No
Suddenly.
proceeding, no notice even.
No notice.
And there are two affidavits in the form of report, two reports in the form of affidavits before the learned single judge, my lord, by the municipality as well as by the state, my lord, indicating what the position is. In none of the reports, there is even an attempt to, my lord, establish that there was any prior notice issued for any hearing or even demolition. They have not even tried to justify. The only justification is that this property is in Khotian 1. That is the state's affidavit. And the municipality's affidavit, I do not find any records. So I demolish. So these are the two stand which has been taken. But if your lordship so desires, I can place it once to refresh your lordship's memory.
The order,
The
reports. Reports. What you have said is sufficient.
Now, my lord, as your lordship has seen, my lord, the running medicine shop was demolished one day and entire shop is now gone. So, my lord, this would, in my humble submission, would be a constitutional tort as well, which the my lord, the respondents would be liable to, my lord, compensate. But this really fell from your lordship, and we have tried to, my lord, do some research to assist your lordship. My lord, this law, my lord, really started from, my lord, a judgment, my lord, concerning a custodial death. And the main judgment, the parent judgment is the in the case of Rudal Shah. Rudal Shah, my lord, that is reported at 1983 volume 4, Supreme Court cases 141. 140.
Mr. Gupta, just one minute. Give us 1 minute. This is not a point that is often argued, but with respect, I am remembering the late lamented Ashish Shannal, who had argued. Have you seen him? Of course you have seen him, no? Mr. Ashish Shannal, no?
Possibly not.
He used to practice mainly on the appellate side. He was a senior counsel. I can't remember if he was designated senior counsel. He had argued constitutional tort before me when I was sitting singly at some point of time. This first time and only time it has been argued before me.
In fact, I was also trying and looking up for the judgments. There are hardly any. Especially in our High Court, there's hardly any.
Which is the one now? Tell us.
This is 1983, volume 4, Supreme Court cases 141. And my lord, I shall be relying on paragraphs 8 to 12. My lord, may I hand up copies of this? My lord, this emanated from an incident of, my lord, custodial death. Paragraph numbers 8 to 12.
Illegal detention possible. The Rudal Shah possibly illegal detention.
Illegal detention and illegal demolition.
But Article 21, that the powers are, my lord, the scope is, my lord, widest possible. My lord, kindly sees paragraph 8, my lord, at page 146. That takes us to the question as to how grave injustice which has been perpetrated upon the petitioner can be rectified, insofar as it lies within our power to do so in exercise of our writ jurisdiction under Article 32 of the Constitution. The article confers power on the Supreme Court to issue directions or orders or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari, whichever may be appropriate for the enforcement of any of the rights conferred by Part 3. The right to move the Supreme Court by appropriate proceedings for the enforcement of the rights conferred by Part 3 is guaranteed. That is to say, the right to move the Supreme Court is under Article 32 for the enforcement of any of the rights conferred by Part 3 of the Constitution is itself a fundamental right. It is true that Article 32 cannot be used to substitute for the enforcement of rights and obligations which can be enforced efficaciously through the ordinary processes of courts, civil and criminal. A money claim has therefore to be agitated in and adjudicated upon in a suit instituted in a court of lowest grade competent to try it. But the important question for our consideration is whether, in exercise of its jurisdiction under Article 32, this court can pass an order for payment of money if such an order is in the nature of compensation consequential upon the deprivation of a fundamental right. The instant case is illustrative of such cases. The petitioner was detained illegally in the prison for over 14 years after his acquittal in a full-dress trial. He filed a habeas corpus petition in this court for his release and from illegal detention. He obtained that relief, our finding being that his detention in the prison after his acquittal was wholly unjustified. He contends that he is entitled to be compensated for his illegal detention and that we ought to pass an appropriate order for the payment of compensation in this habeas corpus petition itself. I'm not pausing it for a moment, my lord. The 93 judgment was illegal detention. There's a wrong noting. The other judgment which actually places.
Yes, but mind you, this was fundamental right.
Yes.
300 days, no more fundamental right.
But there was a right of business also. So it is not only 300A.
Article 19.
Yes, and also, my lord, right to life and livelihood. So, my lord, it is not only the property, but others also being affected. And my lord, in my humble submission, possibly, Article 32 is only limited to fundamental right, but 226 is also for enforcement of any other legal right. So, my lord, possibly, your lordship's powers under 226 is even wider than 32. So, that way also, possibly your lordship would also, my lord, that 300-day violation can also be imported in 226 powers and
any constitutional right.
Constitution or even a legal right. So 226 also, the language is also for respect of a legal right. So 32 powers are wide, but 226 is wider.
Wider. That the Supreme Court itself has said. Wider.
So, may I just read on, my lord? We cannot resist this argument. This has been developed, but since this is the source, I am just placing the two paragraphs. We cannot resist this argument. We see no effective answer to it to save the stale and sterile objection that the petitioner may, if so advised, file a suit to recover damages from the state government. Happily, the state's counsel has not raised that objection. The petitioner could have been relegated to the ordinary remedy of a suit if his claim to compensation was factually controversial, in the sense that a civil court may or may not have upheld his claim. But we have no doubt that if the petitioner files a suit to recover damages for his illegal detention, a decree for damages would have to be passed in that suit, though it is not possible to predicate, in the absence of evidence, the precise amount which would be decreed in his favor. In these circumstances, the refusal of this court to pass an order of compensation in favor of the petitioner will be doing mere lip service to his fundamental right to liberty, which the state government has so grossly violated. Article 21, which guarantees the right to life and liberty, will be denuded of its significant content if the power of this court were limited to passing orders of release from illegal detention. One of the telling ways in which the violation of that right can reasonably be prevented and due compliance with the mandate of Article 21 secured is to mulct its violators in the payment of monetary compensation. Administrative sclerosis leading to flagrant infringements of fundamental rights cannot be corrected by any other method open to the judiciary to adopt. The right to compensation is some palliative for the unlawful acts of the instrumentalities which act in the name of the public interest and which present for their protection the powers of the state as a shield. If civilization is not to perish in this country, as it has perished in some others, too well known to suffer mention, it is necessary to educate ourselves into accepting that respect for the rights of the individuals is the true bastion of democracy. Therefore, the state must repair the damage done by its officers to the petitioner's rights. It may have the recourse against those officers. Taking into consideration the great harm done to the petitioner by the government of Bihar, we are of the opinion that as an interim measure, the state must pay to the petitioner a further sum of rupees such and such in addition to the sum of rupees such and such already paid by it. The amount shall be paid within 2 weeks. This order will not, paragraph 12, this order will not preclude the petitioner from bringing a suit to recover appropriate damages from the state and its erring officials. The order of compensation passed by us, as we have said above, is in the nature of a palliative. We cannot leave the petitioner penniless until the end of the suit, the many appeals and the execution proceedings. A full-dress debate on the nice points of facts and law, which takes place leisurely in compensation suits, will have to wait the filing of such suit by the poor Rudal Shah. The Leviathan will have liberty to raise those points in that suit.
Very nice.
Short and crisp, my lord. Senior my lord Justice Chandrachud. Then the next judgment, my lord will kindly permit me to place 1993, Volume 2, Supreme Court Cases 746.
You're appearing.
This is a judgment passed relying upon the previous judgment of Rudal Shah, but this has elaborated the field like no other. I shall be placing reliance on paragraphs 10 to 26 and 30 to 36.
10 to 26.
And 30 to 36.
Yes.
Just to give your lordship the background on which this was passed, kindly takes a look at paragraph 1. There is no paragraph number as such, but that is paragraph 1, my lord. 752, page 752. A letter dated September 14, 1988, sent to this court by Srimati Ninabati Behra, alias Lalita Behra, was treated as a writ petition under Article 32 of the Constitution for determining the claim of compensation made therein consequent upon the death of the petitioner's son, Shuman Behra, aged about 22 years, in police custody. The said Shuman Behra was taken from his home in police custody at about 8 a.m. on December 1, 1987 by the respondent number 6, Sharad Chandra Barik, Assistant Sub-Inspector of Police of Jeriakala Police Outpost under Police Station, Bishra, District Sundargarh, Orissa, in connection with investigation of an offence of theft and detained the police outpost. At about 2 p.m. the next day, the petitioner came to know that the dead body of her son, Shuman Behra, was found on the railway track near the bridge at some distance from Jeraikala railway station. May I pause here for a moment? Your lordship would kindly juxtapose the situation here. The petitioner goes off to sleep with locking his store. Next morning, there is nothing. So, this is not right to life, of course, but livelihood is involved and the right to carry on the business of trade and profession. Then kindly turns over to page 738 at paragraph 10. 758, I'm sorry, at paragraph 10. In view of the decisions of this court, in Rudal Shah and certain other judgments have been mentioned, the liability of the state of Orissa in present case to pay the compensation cannot be doubted, and it was rightly not disputed by the learned additional Solicitor General. It would, however, be appropriate to spell out clearly the principle on which the liability of the state arises in such cases for payment of compensation, and the distinction between this liability and the liability in private law for payment of compensation in an action on tort. It may be mentioned straight away that award of compensation in a proceeding under Article 32 by this court or by the High Court under Article 226 of the Constitution is a remedy available in public law based on strict liability for contravention of fundamental rights, to which the principle of sovereign immunity does not apply, even though it may be a defense, it may be available as a defense in private law in an action based on tort. This is a distinction between the two remedies to be borne in mind, which also indicates the basis on which compensation is awarded in such proceedings. We shall now refer to the earlier decision of this court as well as in some other decisions before further discussing of this principle. My lord, I am not placing paragraph 11 because it is my lord Rudol Shah. Then my lord kindly comes to paragraph 12. Paragraph 11 is the quotation from Rudol Shah. Paragraph 12. It does appear from the above extract that even though it was held that compensation could be awarded under Article 32 for contravention of a fundamental right, yet it was also stated that the petitioner could have been relegated to the ordinary remedy of a suit if his claim to compensation was actually controversial. And Article 32 cannot be used to be a substitute for the enforcement of rights and obligations which can be enforced efficaciously through the ordinary processes. This observation may tend to raise a doubt that a remedy under Article 32 could be denied if the claim to compensation was factually controversial and therefore optional, not being a distinct remedy available to the petitioner in addition to the ordinary processes. The later decisions of this court proceed on the assumption that monetary compensation can be awarded for violation of constitutional rights under Article 32 or Article 226 of the Constitution, but this aspect has not been adverted to. It is therefore necessary to clear this doubt and to indicate the precise nature of this remedy, which is distinct and in addition to the remedy, addition to the available ordinary processes in case of violation of fundamental rights. Then, my lord, kindly, my lord, takes a look at paragraph, my lord, 14. In this context, it is sufficient to say that the decision of this court in Kasturilal upholding the state's plea of sovereign immunity for tortious acts of its servants is confined to the sphere of liability in tort, which is distinct from the state's liability for contravention of fundamental rights to which the doctrine of sovereign immunity has no application in the constitutional scheme and is no defense to the constitutional remedy under Articles 32 and 226 of the Constitution, which enables award of compensation for contravention of fundamental rights when the only practicable mode of enforcement of the fundamental rights can be award of compensation. The decisions of this court in Rudol Shah and others in that line relate to award of compensation for contravention of fundamental rights in constitutional remedy under Articles 32 and 226 of the Constitution. On the other hand, Kasturilal related to value of goods seized and not returned to the owner due to fault of the government servants. The claim being for damages for tort of conversion under the ordinary process and not a claim for compensation for violation of fundamental rights. Kasturilal is therefore inapplicable in this context. Kasturilal was a judgment which was pre-Rudol Shah, which has been subsequently not followed. The decision of Privy Council in Maharaj versus Attorney General of Trinidad and Tobago is useful in this context. That case related to Section 6 of the Constitution of Trinidad and Tobago, 1962, in the chapter pertaining to human rights and fundamental freedoms, wherein Section 6 provided for an application to the High Court for redress. The question was whether the provision permitted an order for monetary compensation. The contention of the Attorney General therein that an order for payment of compensation did not amount to the enforcement of the rights that had been contravened was expressly rejected. It was held that an order for payment of compensation when a right protected had been contravened is clearly a form of redress which a person is entitled to claim under Section 6 and may well be the only practicable form of redress. Then Lord Diplock's judgment has been quoted. But may I only place the second quotation at page 762 Placetum C. Finally, their lordships would say something about the measure of monetary compensation recoverable under Section 6, where the contravention of the claimant's constitutional rights consists of deprivation of the liberty otherwise than by due process of law. The claim is not a claim in private law for damages, for tort, of false imprisonment, under which the damages recoverable are at large and would include damages for loss of reputation. It is a claim in public law for compensation for deprivation of liberty alone. Then Muller kindly takes a look at paragraph 17. I'm sorry, my lord, 16 unnumbered. I'm sorry, my lord, 16 unnumbered paragraph, placetum F, just below placetum F. Thus, on this principle, the view was unanimous that enforcement of the constitutional right and grant of redress embraces award of compensation as part of legal consequences of its compensation. Then paragraph 17. It follows that a claim in public law for compensation for contravention of human rights and fundamental freedoms, the protection of which is guaranteed in the Constitution, is an acknowledged remedy for enforcement and protection of such rights, and such a claim based on strict liability made by resorting to a constitutional remedy provided for the enforcement of a fundamental right is distinct from and in addition to the remedy in private law for damages for the tort resulting from the contravention of the fundamental right. The defense of sovereign immunity being inapplicable and alien to the concept of guarantee of fundamental rights, there can be no question of such a defense being available in the constitutional remedy. It is this principle which justifies award of monetary compensation for contravention of fundamental rights guaranteed by the Constitution, when that is the only practicable mode of redress available for contravention made by the state or its servants in the purported exercise of their powers and enforcement of the fundamental rights is claimed by resort to remedy in public law under the Constitution by recourse to Articles 32 and 226 of the Constitution. Then paragraph 18, a useful discussion on this topic which brings out the distinction between the remedy in public law based on strict liability for violation of a fundamental right, enabling award of compensation, to which the defense of sovereign immunity is inapplicable, and the private law remedy, wherein vicarious liability of the state in tort may arise, is to be found in such and such, in the book has been quoted. This view finds support in the decisions of this court in Bhagalpur blindings case and Khatri versus State of Bihar, wherein it was said that the court is not helpless to grant relief in case of violation of the right to life and personal liberty, and it should be prepared to forge new tools and devise new remedies, and it for the purpose of vindicating these precious fundamental rights. It was also indicated that the procedure suitable in the facts of the case must be adopted for conducting the inquiry needed to ascertain the necessary facts for granting the relief as the available mode of redress for enforcement of the guaranteed fundamental rights. More recently, in Union Carbide versus Union of India, Mishra CJ stated that we have to develop our own law, and if we find that it is necessary to construct a new principle of a liability to deal with an unusual situation which has arisen and which is likely to arise in future, there is no reason why we should hesitate to evolve such principle of liability. To the same effect are the observation of Venkatacharya J, who rendered the leading judgment in Bhopal gas case with regard to the court's power to grant relief. We respectfully concur with the view that the court is not helpless, and the wide powers given to this court by Article 32, which itself is a fundamental right, imposes a constitutional obligation on this court to forge such new tools which may be necessary for doing complete justice and for enforcing the fundamental rights guaranteed in the Constitution, which enable the award of monetary compensation in appropriate cases, where that is the only mode of redress available. Perhaps the next sentence is not available to your lordships because it deals with Article 142 powers. But may I skip that and go to the next sentence at placetum B? If the guarantee that deprivation of life and personal liberty cannot be made except in accordance with law is to be real, the enforcement of the right in case of every contravention must also be possible in the constitutional scheme, the mode of redress being that which is appropriate in the facts of each case. This remedy in public law has to be more readily available when invoked by the have-nots, who are not possessed of the wherewithal for enforcement of their rights in private law, even though its exercise is to be tempted by judicial restraint to avoid circumvention of private law elements where more applicable. Then, my lord, paragraph 22. The above discussion indicates the principle on which the court's power under Articles 32 and 226 of the Constitution is guaranteed to award monetary compensation for contravention of a fundamental right. This was indicated in Rudol Shah, and certain further observations therein adverted to earlier, which may tend to minimize the effect of principle indicated therein, do not really detract from that principle. This is how the decisions of this court in Rudol Shah and others in that line have to be understood, and Kasturilal distinguished therefrom. We have considered this question at some length in view of the doubt raised at times about the propriety of awarding compensation in such proceedings, instead of directing the claimant to resort to the ordinary process of recovery of damages by recourse to an action in tort. In the present case, on finding reached, it is a clear case for award of compensation to the petitioner for the custodial death of a son. Then, my lord, there is a concurring judgment of my lord Justice Anand, which starts from paragraph 26. My lord will kindly take a look at paragraph 30. On basis of the above conclusion, we have now to examine whether to seek the right of redressal under Article 32 of the Constitution, which is without prejudice to any other action with respect to the same matter, which may be lawfully available, extends merely to a declaration that there has been a contravention and infringement of the guaranteed fundamental rights, and rest content at that by relegating the party to seek relief through civil and criminal proceedings, or can it go further and grant redress also by the only practicable form of redress, by awarding monetary damages for the infraction of the right to life? It is axiomatic that convicts, prisoners, or under trials are not denuded of their fundamental rights under Article 21, and it is only such restrictions as are permitted by law which can be imposed on the enjoyment of the fundamental rights by such persons. It is an observation of the state to ensure that there is no infringement of the indefeasible rights of a citizen to life except in accordance with law while the citizen is in the custody. The precious right guaranteed by Article 21 of the Constitution of India cannot be denied to convicts, under trials, or the other prisoners in custody, except according to the procedure established by law. There is a great responsibility on the police or prison authorities to ensure that the citizen in its custody is not deprived of his right to life. His liberty is in the very nature of things circumscribed by the very fact of his confinement, and therefore his interest in the limited liberty left to him is rather precious. The duty of care on the part of the state is strict and admits of no exceptions. The wrongdoer is accountable and the state is responsible if the person in custody of the police is deprived of his life except in accordance to the procedure established by law. And once again, my lord, may I humbly, my lord, pause here for a moment, and my lord, beseech your lordships to imagine the situation in our case. My lord, if my property was illegal, though I have a registered conveyance deed, I have the, my lord, mutation certificates, everything. Even if I take the case of the respondents to be the highest, that this was a Khatian 1 land, Khatian 1 property, and that it was vested, then also, my lord, law provides for a due process. Nothing has been even attempted to. So, my lord, this is one of cases that, my lord, the grossness is, my lord, beyond comprehension. So, my lord, even if
Yes.
My lord, kindly turns over to paragraph 34, my lord, at page 768. The public law proceedings serve a different purpose than the private law proceedings. The relief of monetary compensation as exemplary damages in proceedings under Article 32 by this court or under Article 226 by the High Courts for established infringement of the indefeasible right guaranteed under Article 21 of the Constitution is a remedy available in public law and is based on the strict liability for contravention of the guaranteed basic and indivisible rights of the citizen. The purpose of public law is not only to civilize public power, but to also assure the citizen that they live under a legal system which aims to protect their interests and preserve their rights. Kindly permits me to pause here for a moment. My clients were in possession from 2013 to 2022. For 9 years, they were in absolute uninterrupted possession.
Yes.
Paying the khajna demanded by the municipality. On possession guaranteed by the municipality by issuance of the mutation certificate. But may I read on, my lord? Therefore,
This is Maheshtola. Maheshtola.
Therefore, when the court molds the relief by granting compensation in proceedings under Article 32 or 226 of the Constitution, seeking enforcement or protection of fundamental rights, it does so under the public law by way of penalizing the wrongdoer and fixing the liability for the public wrong on the state, which has failed in its public duty to protect the fundamental rights of the citizen. The payment of compensation in such cases is not to be understood as it is generally understood in a civil action for damages under the private law, but in the broader sense of providing relief by an order of making monetary amends under the public law for the wrong done due to the breach of public duty of not protecting the fundamental rights of the citizen. The compensation is in the nature of exemplary damages awarded against the wrongdoer for the breach of its public duty and is independent of the rights available to the aggrieved party to claim compensation under the private law in an action based on tort through a suit instituted in a court of competent jurisdiction and or prosecute the offender under penal law. The court and high courts, being protectors of civil liberties of the citizen, have not only the power and jurisdiction, but also an obligation to grant relief in exercise of its jurisdiction under Articles 32 and 226 of the Constitution to the victim or the heir of the victim whose fundamental rights under Article 21 of the Constitution are established to have been flagrantly infringed by calling upon the state to repair the damage done by its officers to the fundamental rights of the citizen, notwithstanding the right of the citizen to the remedy by way of a civil suit or criminal proceedings. The state, of course, has the right to be indemnified by and take such action as may be available to it against the wrongdoer in accordance with law through appropriate proceedings. Of course, relief in exercise of power under Article 226 or under Article 32 or 226 would be granted only once it is established that there has been an infringement of the fundamental rights of the citizen and no other form of appropriate redressal by the court in the facts of circumstances of the case is possible. The decisions of this court in the line of cases starting with Rudal Shah versus State of Bihar granted monetary relief to the victims for deprivation of their fundamental rights in proceedings through petitions filed under Article 32 or 226 of the Constitution of India, notwithstanding the rights available under civil law to the aggrieved party, where the courts found that the grant of such relief was warranted. It is a sound policy to punish the wrongdoer, and it is in that spirit that the courts have molded the relief by granting compensation to the victims in exercise of their writ jurisdiction. In doing so, the courts take into account not only the interest of the applicant and also the respondent, but also the interest of the public as a whole, with a view to ensure that public bodies or officials do not act unlawfully and do not perform their public duties and do perform their public duties properly, particularly when the fundamental right of a citizen under Article 21 is concerned. Law is in the process of development, and the process necessitates developing separate public law procedures as also public law principles. It may be necessary to identify the situations to which separate proceedings and principles apply, and the courts have to firmly act, but with certain amount of circumspection and self-restraint, lest proceedings under Article 32 or 226 are misused as a disguised substitute for civil and private law. Some of these situations have been identified by this court. Then kindly turns over to the looks at the next last paragraph. Monetary compensation has been awarded. The next judgment, which I seek to rely upon is 1997, Volume 1, Supreme Court Cases, 416.
1997, 1 SCC.
416. Paragraphs 43 to 47 and 54.
To 47 and 54.
And 54.
54.
Yes. But here, I'm not placing these judgments in great detail because, this quotes, certain other judgments. Only, kindly takes a look at paragraph 44. The claim in public law for compensation for unconstitutional deprivation of fundamental right to life and liberty, the protection of which is guaranteed under the Constitution, is a claim based on strict liability and is in addition to the claim available in private law for damages for tortious acts of the public servants. Public law proceedings serve a different purpose than the private law proceedings. Award of compensation for established infringement of the indivisible rights guaranteed under Article 21 of the Constitution is a remedy available in public law, since the purpose of public law is not only to civilize public power, but also to assure the citizens that they live under a legal system wherein their rights and interests shall be protected and preserved. Grant of compensation in proceedings under Article 32 or 226 of the Constitution of India for the established violation of the fundamental rights guaranteed under Article 21 is an exercise of the courts under public law jurisdiction for penalizing the wrongdoer and fixing the liability for the public wrong on the state which failed to discharge of its public duty to protect the fundamental rights of the citizen. Now, kindly turns over to page 443, paragraph 54, where my lords were summing up their findings. Thus, to sum up, it is now a well-established proposition in most of jurisdictions that monetary or pecuniary compensation is an appropriate and indeed an effective and sometimes perhaps the only suitable remedy for redressal of the established infringement of the fundamental right to life of a citizen by the public servants, and the state is vicariously liable for their acts. Well, it kindly permits me to pause here for a moment. But here the honorable judges have indicated that perhaps the only suitable remedy. Well, may I try to import this into our case? Well, here is a person whose only livelihood was that medicine shop. Now I have been relegated to a suit.
That how do we know that this was just not one of those small pastimes Do we have sufficient material before us?
But what I have done is I have sworn a supplementary affidavit, which we shall file subject to your lordship granting the leave, where we had, my lord, whatever details we had of the, my lord, amounts which were involved for that store and the cost for setting that up, the stock that we have indicated. The difficulty is we have a few documents. The others were in the store. That also we have mentioned. Whatever documents we had, we have annexed. We have given a calculation subject to your lordship granting us leave to, my lord, file that, because that was not there before the trial court.
File it, file it. Give them a copy.
Yes.
This is not going to finish today. So if you wish, you can file a response if you wish.
Yeah, fine.
Maybe these are all matters of record. We don't know. Give them a copy.
Yes, absolutely. Correct copy.
Well, so far my learned friend cited some judgment relating to the violation of the human rights, relating to custodial killing, illegal detention, either Leelavati Vera or Rudal Shah or other judgment, my lord.
Fundamental right.
Fundamental right that is permissible under public law on a number of occasions. In our court also, my lord, there is a direction, my lord, the motor vehicle second schedule to be taken into consideration on the basis of that schedule in the event of a death in a particular jail, my lord, or jail custodial killing, punish killing and all these things. So that is, my lord, so far the property related issues are concerned, my lord. I humbly, my lord, raise my voice on the next occasion, my lord, when I will get opportunity. I'll...
He has not finished.
Yes.
But I could manage to find two judgments on demolition where municipality is there. One by Bombay, one by Arc.
You wish to continue after recess or you want some other day? Up to you entirely. Your learned friend is nodding his head like that.
So, well, I shall come back, sir.
Why you're busy after recess?
No, well, the second half, my lord.
Hip, very good. Supplementary affidavit filed on behalf of the appellants in court today be kept with the records. Stop. A copy of such affidavit has been made over to learned advocate for the municipality, which shall be at liberty to file its response on or before the next date, 7 days.
Yes, well, in the one of the REIT application, there was no direction for exchange of affidavit, my lord. That is also difficult.
Oh.
At the motion stage, my lord, at the
So
very threshold, my lord.
Would you file a comprehensive opposition then to the stay application and the
Supplementary affidavit, my lord.
which থেকে কেটে দাও? Made over to the learned advocate for the municipality. Paragraph. Since no affidavits were called for by the learned single judge, it may be appropriate that the municipality files a comprehensive affidavit before us dealing with the appellant's essay for apostrophe, stay petition and the supplementary affidavit. Stop. Let such affidavit in opposition be filed. Don't take too long, we'll forget.
3 weeks, my lord.
Huh?
2 weeks. Well, the state is also there, my lord. Up to the, my lord, the information supplied by the state, this is within Kotian number 1. It's a wasted land.
তাহলে, let affidavit in opposition by the respondents.
My lord.
Be filed within 2 weeks from date to the other. Stop. Reply thereto, if any, be filed within 5 days thereafter. List the matter. List the matter 3 weeks hence. 3 weeks hence as the first item under the heading. 3 weeks hence under the heading special effects matters. Let affidavits be on record, Mr. Gupta, because if we are ultimately with you.
I understand, absolutely.
Yes.
But there were two affidavit reports in the form of affidavits.
Two reports have been called for.
Let those be brought on record also.
Well, those reports are already annexed to the state petition.
Well, we have seen in the newspaper publication from the newspaper, my lord, some my lord, reach court judge, my lord, invoked, my lord, the principle, my lord, popularly following this over here, my lord. The bulldozer, my lord, now culture of bulldozer is going on in Uttar Pradesh. No, God, that information they dealing with paper.
There's a judgment which I have come across by an honorable single judge of this honorable court, where an eviction order was passed in a writ petition.
Yes. Yes, there's an appeal pending before us. In fact, judgment reserved.
So I did not.
Yes. Mr. Tilak Basu is the aggrieved party. Indian Oil
Indian Oil
Corporation.
Corp. I did not know that the pendency.
Lordship is going to iron out the creases.
My brother is in the process of writing. Very well.
লিখে ফেলেন আপনি তাহলে আর হবে না আমাকে একটা কপি দিতে হবে কিন্তু Number 13.
Second call হচ্ছে কিন্তু।
Gochanpur.
Item number 14.
15, but I appeal for the respondents. Your Lordship heard this matter on some occasions. These two appeals.
Yes, Mr. Chakraborty has completed.
Mr. Chakraborty has not completed, but your Lordship, my Lord, was questioned, my Lord, about that. He put made a submission, and your Lordship also considered that in the prayer, in the my Lord, before the Honorable Single Bench, that during the pendency of the appeal before the learned tribunal, there is a change in the 400 provision of 400 section, 400 where the third provision is coming to regarding the regularization, minor construction. And that in fact, my Lord, considered by the Honorable Single Bench, that was his prayer. And then the court wanted to know from the municipal commissioner whether it could be allowed to be retained or not. And the municipal commissioner submitted a report. He said that I have not received the report. The report is with us. We have supplied them on the next last occasion. I have supplied the copy of the report. And they say the major construction, the municipal commissioner said that it cannot be allowed to be retained. And that is the issue. But he insisted on, my Lord, sending the matter to the learned tribunal once again.
Yes.
But the thing is this, my Lord, I submit to this, my Lord, that cannot be right now, my Lord, that cannot be done. It's first of all, it's a long pending matter. And although, my Lord, 2015, the amendment has come, that third provision has been incorporated.
And the rules have been framed.
Rules have been framed because of the reasons that my Lord, Mr. Soumitra Pal passed an order upon interpreting the section 400.
There is no scope for post facto.
Yes, but earlier to that, but that was the interpretation earlier to that, of course, not of judicial pronouncement, there's an order, but in practice, but the word as used, my Lord, in the section itself, the court considered, my Lord, that the power of relaxation was there. In fact, my Lord, in many cases, it had been done. Retention prayer, paid, considered, sometimes it was allowed, sometimes it was rejected. But in all the cases, the prayer was made that because the word said that the municipal commission may demolish the order, may demolish the unauthorized construction. That is the language of the section. And therefore, my Lord, up till before the judgment passed by the division as a single bench, regarding that the section, my Lord, itself says the order of the unauthorized construction is there, it is to be demolished. That is the reasons, my Lord, the corporation thought it fit that because it was already there and the judgment has come in that way, therefore they thought it fit to incorporate that third provision. It's not that, my Lord, that it was not there. In fact, it was in practice and it was, my Lord, considered all through the learned tribunal and also the special officer building. And therefore, my Lord, it is not that, and the High Court also considered.
There is a circular from KMC that 10 meters, 25 meters, if retains, it can be retained after payment of certain fees. There is a circular, I think.
Well, in fact, I am submitting, my Lord, as such, my Lord, there is no guideline earlier to that what would be the constructions to be allowed, because section itself says that without construction, without, my Lord, permission, my Lord, no, my Lord, constructions to be made. Therefore, actually, it is, my Lord, the consideration by the judicial authority or judicial forum, court, what could be said to be the minor nature of construction. But if I say, my Lord, it's a minor nature, I am allowing it. But if it comes to your losses court, your lordship could say that having regard to the facts and some of the case, my Lord, whether it could be said to be minor one or not.
Mr. Ghosh, I remember this much. Rule 4 of the 2015 rules, it enumerates certain factors.
No, now it has been certain factors have been done because the minor construction that has been explained, the minor construction and what could be the minor that has been, my Lord. In fact, my Lord, that some of the guidelines have been given, and on such basis it is done,
including national laws, my Lord.
Yes, sir.
National law is everything.
But this is 10 meters, 25 meters is a minor. But here,
no, 10 meters, 25, I can't say, but it's a minor. Because my lord, I don't say, my lord, I say, my lord, that in having regard to the nature of the sanction obtained, therefore the minor consequence is minor. Minor my lord, cannot be a major one.
Yes, I have.
Minor is always, my lord, I may say, my lord, that a small, my lord, veranda has been constructed without affecting anybody's right. Is beyond necessity. In the process of making construction, somebody feels that I have not obtained my lord, sanction, but it can be done. That's beyond necessity.
But KMC has issued this circular that 10 meter or exceeding 10 meters, 20 meters.
Your lordship, my lord, don't say about the administrative authority decision, but my lord, somebody has to consider, my lord, in the light of the fact. But so long, my lord, whatever the decision of the authorities, my lord, goes in favor of the parties, no challenge is thrown. But when it goes against, then the challenge comes. But your lordship, my lord, whenever the matter comes, your lordship may take a judicial notice of the fact and may pass an appropriate order in any particular case. That regarding whatever the guidelines, whatever the decisions, your lordship could say that, even though it is not challenged. Having regard to consideration of a particular case, then your lordship may say that the scope of the provisions of the particular act, what does it mean? And in that light, your lordship could give an enlightenment of the
Then, my lord, I may be allowed to place 100 judgment where Kolkata Municipal Corporation
I'm not
regularized 2-3 stone,
I mean, not
considering that
disputing
minor.
that, but that is there.
100 judgment is there, my
He
lord.
does not challenge that, but he comes, my lord, that to get the benefit, because I have, my lord, allowed wrongfully, I say, that wrongfully allowed the two-story building to stand. He comes with reference to that I should also be allowed. But he is not challenging that it should not be allowed. But
No.
there will be the guiding factor.
Then, my lord, the popular question to be raised by the Kolkata Municipal Corporation, why you are raising all this question? You are not living in and around of that particular premises. You are residing on Salt Lake or you are residing at North Calcutta, South Calcutta. Why you are raising question with regard to the College Street matter?
No, tell us one thing. The tribunal, when the tribunal dismissed your appeal, the amendment had not come.
No. At that point of time, amendment was there.
Was there?
Yes, my law was there. That is our submission before this honorable court. That is to be taken into consideration and ordered to be passed, considering, my lord, the change position of the law.
No, but change position was already there when the tribunal was disposing of the appeal.
Without considering, without, my lord, writing a single word, that
He did not urge that issue at all. He did not urge that issue at all, my lord. My lord, when the matter comes before the court, before the honorable single bench, he argued, my lord, at length. Thereafter, my lord, he said,
Reference thing. So your instruction is not to agree to a remand to the tribunal.
because of the reasons, my lord, he made a specific prayer before the single bench. In fact, 400, my lord, if the consideration is to be made, then it is to be primarily considered to be made by the municipal commissioner. The matter was sent to the municipal commissioner. Municipal commissioner has given a detailed report. If your lordship wants that my landlord has not been served, that is his prayer, it has been served with a copy of the order when the order judgment has been passed. Then, my lord, he has now been supplied. Now, if he takes an exception, whatever way he can, then your lordship could have decided the entire issue because it's long pending matter. Instead of sending the matter back, the learned tribunal once may say again the municipal commissioner to consider. Municipal commissioner had already, under the direction of this division of this honorable court, has passed the order that it cannot be allowed, having regard to the volume of the nature of the unauthorized constructions. Therefore, if he takes one an exception to that report, let him submit a report before lordship's court and let you consider that whether having regard to the findings recorded by the learned tribunal and the objection my learned is taking, whether it could be allowed or not.
Problem is, Mr. Ghosh, the tribunal can delve into factual aspects. Whether the facts stated in a report or wherever are correct or not. We can't. We can't go and investigate.
Factual aspect has already been dealt with by the learned tribunal in details. In the order, my lord, it has been stated what is the nature of the construction, along with all other points he has taken.
Yes, but there is no reference to the third proviso or the rules framed in connection therewith. No reference at all.
But in absence of that, my submission of lordship that Even in absence of that, the section as it was earlier, if I take it that third proviso was not there, even then the section itself, all the time it was under consideration of the authorities and also the learned tribunal, that whether it will be allowed, because is a issue has been framed. Issue was framed, my lord, whether before the special visa building event, whether it could be permitted or not. That issue was there.
Very well, let us hear out the appeal. We'll pass orders.
Now I have, my lord, given a report to him. If he, my lord, wants, my lord, that if anything to be
Rajiv, Rajiv, কিছু না, আমরা চাই করতেই পারি, শুনেই আমাদের। বলে দেখো।
Now, if we direct a tribunal to dispose of in a time bound manner within 1 month or 6 weeks.
Well, you will see the year of the case. It's a part of the initial order was passed. That is also under the date of the code in 2012 by the special visa building. Earlier, another round of litigation earlier occasion. Then the court directed for consideration.
But in each and every case in tribunal, my lord, only one indulgence. In each and every case in tribunal, my lord, the lower court record is required to be produced within a stipulated period of time. KMC, my lord, not in a mood in every case, my lord, to supply lower court record before the tribunal authority. Delay, if any, my lord, that is because of, my lord, Kolkata Municipal.
Anyway, Mr. Ghosh, Mr. Chakraborty, Mr. Ghosh is saying he has supplied you with a copy of the commissioner's report.
No, my lord, if this question, my lord, what we are trying to agitate, my lord, ventilate, my lord, the settled law is, my lord, the change of law is to be considered at the time of hearing appeal. My lord, he was kind enough to direct me, my lord, to bring judgment. I have brought some judgment, one, my lord, relating to other, my lord, matter, other to Kolkata Municipal Corporation matter.
Mr. Chakraborty, we could have at this stage, without proceeding with the hearing of the appeal, remanded the matter, provided KMC agreed. If KMC doesn't agree, then we have to hear out the appeal and pass a judgment.
Lords.
So proceed.
Then, my lord, the exception, my lord, and senior friend, my lord.
Wish to file an exception then?
Yes, my lord.
Then how long will you take?
1 week, my lord.
1 week. This is a report dated, Mr. Ghosh?
Report dated.
কপিটা পেয়েছো তো তোমার কাছে তো কপিটা আছে তো রিপোর্টে না কেন আগের দিন দিলে তো
28 June. Sorry. Well, I'm sorry.
30th June.
30th June.
This was filed before the learned single judge.
Under the decision of the court.
The learned single judge had called for a report from the municipal commissioner. Stop. Such a report dated June 30, 2022 was filed. Stop. Paragraph. One of the grievances of the appellants is that no copy of such report.
It was in our absence also. My lord, the Kolkata Municipal Corporation personnel visited that particular premises in our absence.
No copy of the report was made available to the appellants or their learned advocate. Stop. Further, the report was prepared pursuant to an inspection made in the absence of the appellants or their representative. Paragraph. A copy of the report has been made over by learned advocate on record for the corporation. Two learned advocate for the appellants. Stop. The appellants seek 1 week's time to file an exception thereto. Stop. Paragraph. List the matter once again on 14th August. We keep it, huh? You will come to court.
After that, you will fix everything.
My lord,
16th. We know. We'll all come to court, but 80% of learned advocates will not.
No, but I'm thinking about 14th August. My lord, that was direct action day in the year 1946, my lord. Now in
Good.
I will excuse my lord.
16th August. August 16. Huh? Stop. On that date, exception to the report be filed. Stop. Advance copy of the exception be made available to learned. You are for the?
My lord, I am for the private respondent.
Be made available to the learned advocates for the other parties before the next date of hearing.
Deeply applied. My lord, only thing, my lord, the report which is there available, my lord will find it from the report. The D-sketch plan, they have not diverted or they have not made any new statement. It is only the square feet which was already there in the D-sketch plan.
Are you supporting or opposing the report?
My lord, I am opposing. I'm not. My humble submission is I need not rely on the report at all.
Don't rely.
Deeply.
$15 will also stand adjourned.
Yes, my lord.
Same.
কিছু লিখতে হবে না 15 থেকে অর্ডার কি করবো 15 14 এ অর্ডার করলাম
Item number 16.
We are paying for the appellant.
16 for the appellant. Private respondent.
private respondent state who is the answering respondent
My lord, the answering respondent should be 4-5 society.
4-5 I am appearing.
Society.
No, not society. Private respondent.
4-5 private respondent.
Private respondent. Achha, private respondent. Fine.
but society is a party
Yes, society is party.
is society represented
They don't appear.
eh?
They are not appearing.
state
State.
My lord,
Mr. Even then, Mr. Bordon, we'll just run through once. This is the first call. I'm going to run through করে দাও
Sure.
এটা first call তো
Item 17.
17 minute I appear for the.
will you do it today after this matter previous matter we'll first take up
Mr.
and also Mr. Mukherjee is not here Mr. Mukherjee is not here
Yes.
Item 18.
Like 18 manner, I'm appearing for the appellant manner in this matter. And your lordship manner granted me liberty to file a supplementary affidavit manner on last occasion. And also manner, I have corrected the cost title as per your lordship direction manner that has been already in the record.
May we use my lord, maybe react to the supplementary affidavit by an appropriate.
Yes.
18
18. My lord. I am for the private respondent.
Very good. Is it clear? My lord,
oh
my supplementary
supplementary affidavit filed in court today comma on behalf of
on behalf of the
appellant.
appellant. Yes.
comma be kept with the records stop copies of the affidavit be made available to learned
They have
advocates for
already
the
been
other parties copies have been made available paragraph learned advocate for
Respondent number 7.
respondent number 7 you are skyline
And skyline.
respondent number 7 bracket leco skyline seeks leave to file a response to the said affidavit stop let such response be filed within
A week.
from date ta diye dao
And
File a response to this affidavit if required, because the instructions are still awaiting. If any instruction is required, which is called.
আচ্ছা শোনো কেটে দাও যা বললাম ওই নেক্সট প্যারাটা কেটে দাও the respondents will be at liberty to file response to the said affidavit
Kindly give us a fortnight then. Corporation will
liberty
take
manner-
some time.
liberty to file a reply if required.
supplementary the response then reply
Well, I don't know what they will come with. No, that much of
within a fortnight date ta diye daw from date stop rejoinder thereto may be filed by the appellant within a week thereafter. Paragraph lists the matter প্রত্যেকটা তারিখ দিয়ে দেবে ব্র্যাকেটে List the matter 3 weeks hence. Tarik diye daw.
हाँ
19, Lordship, I am for the petition. I am for the appellant led by Mr. Shubhra Prakash Lahiri, Your Lordship. He is suffering from high fever and chest infection. I am praying for not this week. Great, deeply.
20, 21,
I am for the private respondent, my lord.
22, 23, 24, 25, 26.
26, my lord, I appear for the applicant. My lord, I have filed an application for substitution. My lord, this is the matter of 2006. My lord, most of the the respondents has been either retired or my lord transferred. That's why, my lord, I have paid for substitution application, my lord, at para 3 and 4. My lord. Kindly have a look at para 3 and 4.
Your Lordship, my learned friend is praying for the addition of my client as a contemner, Your Lordship.
I'm sorry. I appeal for the petition in matter. Give me one moment.
Your Lordship, my instructions are that they want me to be added as a party in this instance.
The microphone may not work if you don't switch it on.
My lord, it's showing it's switched on its
It is.
screen.
How are you doing, Pulraj?
Application. This is my application, my lord, for addition of the present incumbent as a party in the contempt application. The contempt is against the bank.
Yes, the Mr. Mitro has retired.
Yes, my lord, either he is retired or he has transferred, but he's no more in the bank. So, my lord, we are trying to plead Mr. Atul Ahuja, the senior manager of that branch, as the present incumbent, because, my lord, your lordship knows primarily the contempt is really against the bank.
Have you served them?
Your Lordship,
Yes,
I
sir.
appear for Mr. Ahuja. Your
Yes.
Lordship, however, my instructions are that the bank is already a party in this matter, Your Lordship.
Bank can't be sent to jail.
No, indeed, Your Lordship. But Your Lordship, my client is not aware about any of these
We
facts
will
that
serve
have
the application,
transpired,
madam.
that have
Once he's
transpired.
added, we'll serve the contempt application.
Madam, these are formal applications. Let him be added. If he has to say something, let him say on affidavit.
Grateful.
The learned advocate for the petitioner says that the respondent number 1, who was the operation manager of the Standard Chartered Bank at the old Courthouse Street branch, comma, is no more in that branch. Stop. Maybe he has retired or transferred to some other branch. Stop. Accordingly, this application has been taken out. For adding Mr. Atul Ahuja, comma, senior branch manager, comma, Standard Chartered Bank, having his office at 19 Netaji Subhash Road, Calcutta 1, as added respondent. Respondent. Why do you really need his presence, Mr. Ghosh?
Because, my lord, and one human element is required to comply with the order. The bank.
Why this K.N. Muralidharan is there? Mrs. Shongita
The
Sengupta
only
is
thing
there.
is, yes, madam, the only thing is that we are, as per instructions, they are not in the bank. So the only person
They are where?
that we do not know.
None of these persons are with the Standard Chartered Bank.
No, no, it's not there. Because my lord, 2006
No,
contempt
no,
application.
but this is 2006.
2006 contempt application, my lord. To 2012, it has been renumbered, but the application was in 2006.
তারা এরকম ভাবে করো তুমি যে maybe they have retired or no or not in the bank anymore for other reason. কি বললাম না গোড়ার থেকে পড়ো না বলো the respondent numbers 1, 2, 3 because your submission is the same for all three of them.
All three of them.
Respondent numbers 1, 2, and 3 are no more employees of the Standard Chartered Bank. Stop. Hence, it is necessary to add a responsible officer of the bank as the respondent / alleged contemnor. Stop. For that purpose, this application has been taken out. Stop. Paragraph. Mr. Atul Ahuja, Senior Branch Manager, Standard Chartered Bank, 19 Netaji Subhash Road, Kolkata 1, has been sought to be added as a respondent. Stop. Paragraph. Learned advocate for Mr. Ahuja says that Mr. Ahuja knows nothing about the facts of the case.
Indeed, Your Lordship.
Paragraph. Be that as it may, we are of the opinion that some responsible officer should be added as respondent. Stop. Hence, we allow this application and add Mr. Ahuja as an added respondent. Stop. Learned advocate on record for the petitioner shall carry out appropriate amendment to the cause title of the content petition in content petition. Stop. Let a copy of the amended cause title. Content petition has been served on Mr.
No, my
Ahuja.
lord. No, my lord.
Let a copy of the content petition, after amendment of the cause title, be served on the added respondent and affidavit of service filed in court on the next date. You go through the content petition, consult with your client, come back and make your submission. If necessary, we'll grant you leave to file an affidavit also. We are not saying so today. Paragraph lists the matter. 2 weeks hence or what?
2 weeks, man.
2 weeks hence?
We have to do the amendment, so.
Tariq diye dao. A canter is disposed of.
Your Lordship, may I file the Wakalatnama competency?
ওখানে কি এখানে ফাইল করবে না ডিপার্টমেন্টে কোথায় করবে? It is normally filed in the department, madam.
Grateful, my lord. I'll file it in the department.
Grateful, my lord.
Grateful, my lord.
দাদা ফাইলটা দাও তো
What is this CAN 1? CAN 2 is the application that we disposed of now. Yes, what is this CAN 1?
CAN 1 is one application. So my lord, it was a transferred brief. They do not know about what the CAN 1 is.
Find out next day, tell
We'll
us,
find out.
CAN 1
We'll-
of 2017.
I will come back with that, my lord. Grateful, my lord.
Grateful.
Item number 27. 28.
27.
27 আছে তো?
27 I'm for the appeal. Your Lordship, can I take it up Monday?
Monday? Why, what is the problem today?
What is there?
Shubhi Channel arguing on behalf of my.
Okay, okay. Monday?
Monday.
28.
My lord, this is my modification application. My lord, on the last occasion, my lord, your lordship had passed an order, my lord, directing, my lord, the parties to, my lord, come to a settlement because your lordship recalls, my lord, this was a
We
second.
couldn't have directed the parties to come to a
No, your
settlement.
lordship had said, my lord, if we could, my lord, intimate, my lord, what is the amount that would be, my lord, agreeable, my lord, pursuant to that letter, pursuant to your lordship's order, my lord, we've written a letter.
Oh,
Amount
that occupational charge, occupational charge.
Occupational charge, my lord, Atma Ram, and henceforth, my lord, this is a heart.
Yes,
and
what
Subu-
happened? What happened?
So, my lord, we had written our letter, my lord, indicating, my lord, what is the, my lord, agreed amount, my lord, because my learned friend had, my lord, raised whatever your lord.
You are HPCL.
I am HPCL, my lord.
My lord, I beg to appear for the appellant, Hindustan Petroleum Corporation Limited, my lord.
Appellant.
Appellant, my lord. I'm the appellant, my lord. Appellant herein,
My lord,
They
I
have
am
taken out
my
an
modification application.
They have taken out an application.
My lord, I am
settlement of
not
occupational
HPCL, my
charges.
lord. I am Shoma Roy Chaudhary, my lord. I am the original, my lord.
I said,
letters.
I asked your
I'm sorry.
HPCL, you said yes.
I'm sorry.
Yes.
Sorry, my lord. My lord, I'm late. My
Any
lord-
chance of a settlement or
My
else?
lord, my lord, I'll kindly indicate that, my lord, we are in receipt of a communication from my learned brother's client, my lord.
Why don't you tell us? Why
My
don't
lord, my lord, it states that perhaps they are agreeable to reduce as to the extent that they have sought for modification of the occupational charges to the tune of 9 lakhs, I believe. Now, my lord, we have already sent this to HPCL, my lord, to find out if there can be a consensus addendum somewhere in the middle, my lord.
In short, you need more time.
My lord, kindly grant me
So that in one sentence you could have said.
I'm extremely sorry, my lord.
Master, নশো কথা বলে। Learned advocate for Hindustan Petroleum Corporation Limited says that um, 9,66,000.
That is what they have come down to, my lord.
My lord, because your lordship will, my lord, I had submitted a valuer's report. My lord, the
Whatever
valuation
it
is 11
is,
lakhs.
if you agree, you agree.
Yes, 9,66,000 is what, my lord, my clients have agreed.
Monthly.
Monthly. my-
You will know. The landlords have agreed to accept monthly occupational charges in the sum of rupees 9.66 lakh. Stop. The matter is pending before the competent authority of HPCL. Stop. Some more time is required. How much?
My lord, kindly grant me 3 weeks of time, my
My
lord.
lord,
3 weeks, my lord.
my lord, it is your lordship's, my lord, order, my lord, of July, my lord. This is a 2014 appeal. My lord, they have been fomenting litigation since then.
2 weeks, sir. 2 weeks.
My lord,
Just
the
because.
communication we have received on the 26th of July, my lord. This communication itself.
Oh, you have received on this? That's true. 26th
26th
of
of
July.
July.
No. Very well. And public sector, you know.
Much obliged, my lord.
What obliged? You know? Paragraph. List the matter. 3 weeks hence. Date the other. When learned advocate for HPCL shall come back with positive instructions.
It will be my lord's pleasure to make this preemptory, my lord. Otherwise, I will move my application on the next date, my lord, because, my lord.
You move it next day. Move it. It is made clear that no further time will be granted. No further adjournment will be granted. Stop. even if on the next date, learned advocate for HPCL does not come back with firm instructions, comma, we may have to dispose of the modification application on merits.
And my lord, your lordship's order, my lord, 7th January 2014 had directed them to pay certain occupational charges. My lord, I am instructed, my lord, that for the month of July, they have not paid that. June they have paid, June they paid.
They have paid. In the letter it is written.
For the June, my lord, they have paid, but July, my lord, I am told they have not paid. Are you sure?
From one part for another part. The first line indicated it appears that occupational charges.
Mr. Ayush Jain.
For the month of July.
Yes, my lord, there are two landlords.
Mr. Ayush Jain is
my advocate on record.
Mr. Ayush Jain is writing to Mr. Dilip Kumar Kundu. Who is Mr. Dilip Kumar Kundu?
Their advocate on record.
It appears that occupational charges of such and such for the month of July 23 has been paid to my client.
Yes, my lord, 25,000. There were two, my lord, owners.
Yes.
25,000 per owner, my lord. That was the last direction. My lord, 25,000 they paid to one owner. My lord, the other owner they have not paid.
Take instruction on that. If not paid, definitely you must pay. Yes.
Grateful.
Or I for the respondent number 8. That matter.
No, Mr. Nandi. This is the first call because we'll take it up in the second call. We are running through the list so that small matters can be.
Number 30.
Lord, 30, 31 and 32, Lord. We are paying for the 30, we are paying for the appellant and 30.
Second call. Next.
Authority concern.
I am for repetition of respondent, my lord. I am appearing.
For the municipal tenancy. 35.
Lordship, I'm praying for not this week. In
35. Appellant.
Appellant, your lordship.
36.
33 or 37. In one matter, I appear for the appellant, another matter, I am for the respondent. So since one of my matter is fixed at 3 o'clock before a honorable single bench, your lordship may not be taken up this week, my lord, this matter. And also 17 may also be, my lord, not.
17.
17 and 37.
Very well. Not this week.
Not this week.
17 are AJ Dakle.
47 also. I am for the appellant.
47 also. No. 47 you are not for the appellant.
I'm sorry, my lord. That is the. No, I am the appellant. I am the appellant. Sorry, my lord.
47 Mira Chaudhuri.
Mira Chaudhuri, I am for the Mira Chaudhuri.
Oh, you are from Mira Chaudhuri. ঠিক আছে এগুলো সব not to speak করে দাও।
Item 38. 39. 40.
Item 40, my lord, I am for the petitioner. My senior is coming just therefore I'm praying for a short passover.
41. 42. 43.
43, my lord, I'm praying for the appellant, my lord. I'm praying for not this, my lord.
Not this week.
Grateful, my
44.
44, my lord, I am praying not today, lord.
Lordship, I am for the
Lordship.
only difficulty every day, not today. Every day they are coming and praying for not today.
In not
Every
this
day.
week.
Lordship. Lordship, there is an interim order, Lordship, which the appellants are enjoying, Lordship, that only
Very well. Pass it
hearing
over.
has been almost
Pass
concluded,
it over.
Lordship.
Pass it over.
Grateful, Lordship.
45.
45, lordship, I am for that. Led by Mr. Siddhartha Banerjee. Kindly give me a short password.
46. 48. 49. 50. 51. 52. 53. 54.
54, I'm for the appellant. Not, the other side is also present. I appear for the restaurant number 1.
Yes.
My lord, it's a suit for declaration and
Second one.
55, 56. Second call item number 16.
Yes, Mr. Three volumes, 4 volumes. Are they all in your matter or some other matter?
Same matter.
You're trying to intimidate us.
No, no. I dare not. my lord. These are the list of relevant dates, my lord.
last occasion get submitted.
Your writ petition was dismissed.
My lord, I was the respondent number 5 in the writ petition. My lord, before I take my lord through the nuances of the matter, my lord, may I place, my lord, the impugned order and the order sought for in the writ petition. My lord, the writ petition starts at page 11, my lord. The relevant port, this prayer is at page 33. The prayer is basically one, my lord, at page 33.
Did you hand up this to us? Did you? You did. We'll keep it.
My lord, we've sought to make it a little simpler with the list of dates.
Page?
Well, page 33 of volume 1, my lord.
Yes.
Is the prayer, my lord. A writ in the nature of mandamus commanding and the respondents and pro forma respondent number certain such their officers not to sell, transfer any portion or portions of the purchased car parking space of your petitioner. This is the prayer, my lord. The writ essentially revolves upon, my lord, a car parking space in a cooperative society and the status of the same. Kindly takes the impugned order, my lord, at page 203. So, my lord, the prayer is commanding the respondents and pro forma respondents number their officers not to sell and transfer any portion or portions of the purchased car parking space of your petitioner. And, my lord, the impugned order at page 203. No, 203 minutes. The petitioner assails a writing dated August 19, 2015 in the writ petition. This, what is this writing, my lord? This would appear at page 49, 19th August. My lord, this is the letter from the additional registrar of corporate societies to the chairman of the society. Subject is rectification of indenture of conveyance dated such and such. It appears from the complaint dated 26/6/15, received from Mrs. Srimati Taupati Banerjee, who happens to be the predecessor in interest of the appellant here, a member of the society, that though in compliance of the court order, the society resolved to allot car parking space number 26 in her favor, necessary rectification of the indenture of conveyance in respect of a flat number 2D has not been executed.
The society is advised to comply with the order of the Honorable High Court and the Learned Co-op Tribunal and report compliance. So, my lord, the order impugned proceeds on the basis that this is the writing which has been assailed. May I place it, my lord? The state and the respondent number 5 are represented. It appears from the materials made available on record that the petitioner purchased a flat along with the garage space in a cooperative society. The garage space was earmarked as number 4. The respondent number 5 had issues with the cooperative society, which received the consideration of the arbitrator. An award was passed directing the society to provide the garage space to the respondent number 5. Such award was confirmed by the High Court. The society allotted the garage space being number 26 to the respondent number 5. It cannot be said that the allotted garage space number 26 can overlap or encroach upon any portion of the garage space number 4. The petitioner is entitled to garage space number 4 in its entirety. The society will ensure that the petitioner enjoys garage space number 4 in its entirety. The garage space number 4 is delineated in the title to the petitioner. The society will follow the same. So far as the award of the arbitrator is confirmed by the High Court in respect of the respondent number 5 is concerned, it is open to the cooperative society to implement the same in accordance with law, if not already done. The award of the arbitrator as confirmed by the High Court cannot be read to mean that the cooperative society will encroach upon any other space to comply with such award. Writ petition disposed of accordingly. This is the order, my lord. Now, my lord, so far as the facts are concerned, my lord, kindly takes the trouble, my lord, looking at the list of dates, my lord. So this is a little comprehensive, my lord, but the fact remains, my lord, that a dispute case was started by my client's present interest, my lord. This dispute case, my lord, kindly takes page 59 of the paper book. The order passed by the learned arbitrator is at page 59. It was passed on 17th January 2001. Kindly takes, my lord, page 59. Srimati Tapati Banerjee, a member of the Dakshini Cooperative Society, being aggrieved of not getting a garage space, submitted the instant dispute case against Dakshini Cooperative Society Limited. The written statement as well as the verbal argument of the petition.
Mr. Bordun, don't read the entire award.
My lord, I'll just take then in that even, my lord, kindly sees page 52 is the ordering portion. 62, my lord, 62. Award. That in view of the award observations and from the point of view of natural justice, equity, and good conscience, I pass order that defendant society shall provide garage space facility to the plaintiff at the space on left-hand side of the staircase uplight against rent fees. No cost in regard to the suit is award. Award is given by me in pronouncement presence of learned advocate, such and such, for both the parties. This is the award, my lord. My lord, now this award was carried in appeal by both the parties, my lord. 79 is, my lord, the appellate tribunal's order, my lord. It starts from page 79. My lord, there were two appeals, my lord. One filed by my client's predecessor and one by the, my lord, the defendants. Let's see page 79, my lord. Appeal number 14 filed by defendants and appeal number 18 directed against self-same award dated such and such by the plaintiff. My lord, now the relevant portion of this judgment, my lord, would start at page 92. The tribunal affirms the order. In fact, the award, my lord. May I put it this way? Page 92, my lord, is the tribunal's order, my lord. Page 92.
You have summarized it in your list of dates. We have read it.
Absolutely, my lord. We done it, my lord. So, my lord, kindly takes the trouble, my lord. So the appeal, both are dismissed, affirmed. Then, my lord, review was filed, that was dismissed. Now, my lord, CO, two civil revisional applications were filed, which appears at page 98 and 119. 119, my lord, is the order, my lord, at page 118.
Why is there such a big fight only with respect to a car parking space? What is there really behind the scene?
Car parking, my lord. It's a car parking space.
Go for mediation, sort it out. It's only a car parking space. If two car parking spaces are available, agree on who will take which. Shomir Mitro and Tapati Banerjee. Huh?
And that's a mediation then?
Sorry, not Tapati. Tapati has died.
Yes, my lord. Where is
Shukamul,
it?
Shukamul. Seriously, why don't you try mediation? This is a perfect case for mediation.
There's only one garage. Oh, there's one. I'm told there's only one garage. And my lord, the society is not appearing. Society is not appearing.
Then anything, what will be decided whether in mediation or here will be binding on the society. They have chosen not
If
to
they
appear.
choose not to appear, they'll be binding on them.
Correct. Anyway, proceed. I mean,
Now, my lord, the revisional applications were dismissed. So, my lord, the award still holds the field. Thereafter, my lord, kindly takes page 300 and 311, which says, my lord, the execution was done and the car parking space was handed over to me at page 300, my lord.
so it is now in your possession.
Our position. Yes, it's not our position. Well, we'll take page 311.
And this car parking slot is numbered as what?
Number 26. 26.
26. There is no car parking slot numbered as 4.
4 and 5 are there. Now this 26 interchecks between the 4 and 5.
Justice Boshak said that the writ petitioner will get which one?
Justice Boshak says garage space is in the title of the petitioner.
4, number 4.
The petitioner meaning my learned friend's client.
Yes, so you don't have a garage space now.
No. We have been sold the space 4 to us by a registered deed.
Yes.
Long time back. Now what happened, my lord, they, by virtue of that award,
Yes.
my lord, they have encroached my space and marked it as 26, portion of my space of the garage space 4. My lord.
There are two garage space, 3 and 4.
4 and 5.
3 and 4. 4 we have purchased. What does it have done? Part of 3 and part of 4 taken as 26. And they are going to sell that to them, which was sold to us, which are purchased from the society. Now a portion of our property is being sold to them. That we have challenged them.
আমরা decide করব কি?
The factual issues.
How will the writ court decide this dispute?
And my lord, may I say this?
If they are encroaching on your car parking space, how will we decide that?
And that is wholly extraneous to the writ petition. I've shown, my lord, the prayer in the writ petition. And my lord, that apart, my lord, may I say this? There was an award.
Then let him speak.
So this is a dispute between you and Mr. Bardhan's client. Society is supporting whom?
They are not appearing.
They are encroaching. What list of trades they have given that? What happened to there are many garage space in the building. So there are many garage space in the building. When we apply for flat, please repeat from. There are many garage space in the building. Yes. When we have purchased the flat, we have also applied for a garage space, covered garage space. Cooperative society told us a flat and a garage space. That is garage space. My learned friend, when he applied for the flat, he applied for a flat and a open garage space. That open garage space was not given to him, the society. Then he filed a dispute case. Then initially, he was allotted a garage space that was given in between 5 and 6. 5 and 6 they were allotted. The allotee of 5 and 6 they challenged, and the society also challenged. Then it was held that you cannot give the property which is already been sold. Now they did not got possession of that between 5 and 6. Now they jumped on us, and the executing court given them between a flat portion 3 and 4. So there is no order of the executing court itself. So himself demarcated a portion and allocated it. In the executing court, you are not there. No, I'm not there. Go to executing court. No, whatever I'm telling you. Before that, there is order in lead court. Lead court Justice Putapra said you can keep your card where you are keeping it so long. Then when we find that this was given a portion of us, we went to the lead court. We pointed out. Then lead court has deleted that portion where you are keeping cards so long. That portion was deleted by Justice Putapra. And then we go to the executing court. Executive court, you have come after 3 years. But by limitation, therefore,
If we ensure the presence of the chairman of the society, do you think it's going to help?
Try it.
It could be sorted out. I mean, this kind of a dispute shouldn't engage you or us for so long.
May I say this?
Yes.
Good, bad, indifferent doesn't award.
Yes.
Good, bad, indifferent, award affirmed.
Yes.
They prefer an application before the executing court. It's not that they were unheard. Any dispute with regard to the executability of the award ought to have been challenged in a miss case.
What was the prayer in their application?
Their prayer, my lord. They filed
that just say
they preferred an application under Order 21, Rules 97, 98, 99, 101, 13 in the execution application, in the execution proceedings, which was numbered as miss case. Miss case dismissed, affirmed by this court. Now the question is whether now it is open for them to challenge this award on any score whatsoever. Whether the executability.
Show us the award once, that portion where it says that parking space number such and such.
Award, my lord. Award ta Kolkata ache 59.
Oh, this 17 January 2001.
17 January. Yes.
But this is vague. Garage space facility at the space on the left-hand side of the staircase.
Yes.
Why does it not mention any number?
That time it didn't have a number. So there was 4 and 5. Then the society created this 26 in terms of this order.
That is the grievance. Encroaching his.
So if that was so, they could have raised this issue before the executing court, which they did, and unsuccessful at that. Now whether it's open to them to challenge it before the writ forum. Whether writ at all is maintainable.
It's not mentioned before the executing court that your portion is being encroached. What happened, my lord? At the time of execution, you should have raised objection. At the time of execution, we are not made party.
They filed.
At the time of execution, we are not made party. When our land is in court, then because there is an order of Justice Potapra, we went to Justice Potapra. Justice Potapra deleted a portion which was already passed. Then we go to after deleting that portion to the Justice Potapra's order. Then execution court said, you have come after 3 years. So therefore, your application is time barred. That was not gone into merit.
And that was affirmed by this court.
And what my client.
That was affirmed by this court.
That is applicable order. He came to division. Division court said, this is not.
He was not a party to the arbitration.
No, I'm not a party to arbitration.
Look, a party court.
There is no order from any court that a portion of ours be transferred to them.
এই সত্যি বলছে আমরা কি করে বুঝবো?
If your lordship looks the entire record, your lordship will not find a single award or single order declaring any portion of ours.
Sir, you please tell us how the writ court will decide this issue.
What happened? Cooperative society sold their property to us. Now cooperative society again going to sell a portion of that property to them. That we have said.
That is the factual dispute.
This is admitted position.
Are you admitting?
What?
That
What is admitted position?
Property is ours.
what? Nothing is admitted.
What is sold to us, this is admitted. And
4 is sold to you, but that 26 encroaches on 4 is not admitted.
Yes, 26 is between 3 and 4. A portion of 3 and portion of 4 starts out from your rural sufficient. How can you prove it? The problem. That is from the record. A portion of 3 and portion of 4.
That is what you are saying.
But I am on the issue of maintenance of the writ itself. But I am on the issue of the maintenance of the writ itself. Mulot, the fact is, good, bad, India was the award. Award has been upheld. Now, Mulot, if he has any tangible grievance against the award, he ought to have preferred an application in the execution case, which he did. Which he did.
You'll also find that 3 and 4 carved out and this 26 was created.
Mulot, he might have grievances, Mulot, but that is for the executing court to decide. And he's gone there and that too unsuccessfully. And that dismissal was affirmed by this court.
You are telling that he is not made party.
He preferred a missed case, my lord. In the execution case, he preferred a missed case, or 2197. That was dismissed.
This is
that is with the section 5 application.
Affirmed by this court.
This is a private housing society.
Dismissed. Not
Private cooperative.
Writ will lie. Writ will lie.
Society, against the society, cooperative society.
Private housing society, cooperative society. Show us authority on this. Private body.
Yes.
Private body. How will writ lie?
Good.
Article 12.
You'll occupy come to page 49. This I have said. Page 49.
This is your answer to our query that whether writ will lie or not.
Additional register of cooperative society.
Our query is whether a writ petition lies against a private society.
They are this order. This page 49 order.
Your relief is against a private housing society.
That's why I placed the mandamus that they were seeking.
If you want to do research, do and come back. Prima facie, we are of the view the writ petition is not maintainable, although that was not agitated before the learned single judge. It's a pure point of law.
On one issue, Mulot, having agitated their grievances before the executing court, Mulot, and having lost at that, Mulot, they are stopped from moving the writ court now.
If the first point succeeds, Then nothing, you have to argue nothing.
They are both of fighting.
Yes, yes.
So we can resolve it.
This is what, correct.
Otherwise, without.
This is what I was saying. Since we are adjourning the matter, we are directing the chairperson to appear in person. You are the appellant. You will ensure that a copy of the order is served on the chairman of the society. Sure. We have heard Mr. Bordhon, led by Mr. Chaharai, learned advocates, for some time. Mr. Chaharai, on behalf of the appellant, for some time. Stop. In the course of hearing, a point arises as to whether a writ petition would be maintainable against a private housing society, private cooperative housing society, cooperative housing society. Stop. Paragraph, learned advocate for the respondent oblique writ petitioner seeks a little time to get prepared on that point. When should we keep it? Thursday, next Thursday. Paragraph, list the matter once again on Thursday. Stop. Paragraph, on the next date, the chairman of the respondent cooperative housing society shall appear in person. Not a, hey, do you know who the chairperson is? Chairman, not a lady. No, you don't know. Chairman or secretary. Why both? Or secretary of the
Chairperson, if that.
Chairperson, or no, if it's a lady, elderly lady, we don't know. Chairman or secretary should appear before us to assist us in our attempt to resolve the disputes between the writ petitioner and the appellant. The appellant shall ensure that a copy of this order is made available to the chairman and the secretary of the respondent cooperative housing society.
If it's so commenced to your lordships, at 2 p.m. on Thursday, first half I have some difficulty.
Then don't keep it on Thursday. Keep it on some other day when automatically it will be 2 p.m. If you prefer 2 p.m. keep it on Friday. For a Friday, date. Friday week, date diye do.
I'm so grateful. Item number 20.
No.
I've got a private business. 21 paying for not this week, my lord. Every day he's paying this time of year. Last week.
Why every day you pray for not this week? Every day he can
Every
pray
week,
for.
yes.
Every week, not this week.
Last week I mentioned before your lordship for medical ground, but till date he is sick, my lord. That is why he does not come today.
No, but do it. A long time now pending. Do it next week. Be prepared to do it. Otherwise, you do the matter. Final adjournment, not this week.
Yes.
Hey, 20 ta ki holo?
Lordship, item number 22, 23 and 24 is appearing on behalf of the appellant, Mr. Shamim Ulbari. I'm praying for not today.
He was here just now. We saw him.
Yes, but he gave instruction.
Not today.
For not today. Lodge.
25.
25, this is my
You are for the petitioner.
Yes, yes. Well, today I am.
Have you added the new incumbents?
Yes, yes, yes. Well, today I am filing affidavit in reply, my lord.
I'm for the state lordship, led by Mr. Bishwabroto Boshumoli.
কি ওটা?
Like that. Today I have served upon the state respondent.
Oh, you have filed your affidavit of compliance.
Yes, my lord, I am submitting today filing affidavit in reply, my lord. I have served a copy.
Affidavit of compliance তো filed হয়নি বোধহয়। Madam, are you assisting Mr. Basu Mullik?
Yes, lordship, but he is not come to the court today because he is suffering from his he is suffering from his back pain, so he is admitted in hospital today.
Mr. Basu Mullik is in hospital.
Yes.
When was he admitted?
Tomorrow, actually.
Tomorrow he was admitted.
Yesterday, he is suddenly he is suffering his cardiac.
আচ্ছা, তো নেবই। তো খবর নেব। He is indisposed.
My lord, kindly
Keep
note
this
this.
with you, Sir, Mr. Mondol, you keep this with you because affidavit of compliance কি filed হয়েছে হয়নি। Affidavit of compliance has not yet been filed in court. File this the next day. File this the next day. Keep this with
My
you.
lord, I have served.
That is all right. You serve. File this the
My
next
lord, kindly record it. I have served it.
day. We are told that learned advocate representing the alleged contemnors is indisposed and is in hospital. Paragraph, let this matter stand adjourned for a week and be listed again on Shamne Brishpatibar kore dao. Paragraph, we put it on record that learned advocate for the appellant, petitioner has made over a copy of the petitioner's affidavit in reply
Yes.
to the affidavit of compliance that the alleged contemnor was directed to file. It is not on record. The affidavit of compliance has not yet been filed. Next Thursday, come back next Thursday. Why are you looking so sad?
My lord, I was also unwell, my lord. I have taken 2 days.
No, but you do not have back pain. Do you have back pain?
Yes, my lord.
Mr. Basu Mullik has back pain.
Yes.
So therefore,
Then,
next
my lord,
Thursday.
kindly adjourn 1 week. my lord.
One
Yes.
week. Next Thursday.
Yes.
Yes.
My lord, I have already taken time twice, my lord, before my lord. But I was unwell, my lord.
Are you feeling better now?
Now, my lord.
Good,
yes.
good. Thank you.
For cold and cough, my lord.
Cold and cough.
Yes.
Very bad, very bad.
Item number 29.
My lord.
সেইটা গণেশ let us come back. Let us come back.
দাদা
Again, Mahamlad.
Or on the last occasion, my lord, I was addressing your lordship. I appear for the respondent number 8, my lord, the housing cooperative society, my lord. I was placing before lordship some provisions from the law. Now, my lord, I placed on your lordship, kindly takes the West Bengal Cooperative Societies Act 2006, my lord. To recapitulate, my lord, I started with the definition of the housing cooperative society, my lord. I placed before your lordship section 4, subsection 36. Kindly for once, my lord, takes section 4, subsection 36. My lord, housing cooperative society means a cooperative society, the primary object of which is to provide to its members with dwelling houses, flats, or lands for construction of dwelling houses or flats, or with finance for purchase of land for construction of dwelling houses and maintenance of common services in connection therewith, and includes a federation of such cooperative societies. Now, my lord, housing, my submission on the last occasion, and again I'll be submitting respectfully today also, that the definition itself will be clear that housing cooperative society does not mean that there can be a commercial activity or a shop. Still then, well, there is a provision. I'll show you. For the, he was, my lord, this respondent number 9, he was carrying on, my lord, a shop, converting the car parking space into a shop, and he was selling all the groceries and other various other items. For the purpose of, my lord, if anyone wants to, in a cooperative, if anyone wants to carry out this kind of functions, there is a special provision for that also. That kindly comes to, my lord, section 4, subsection 14, 1(4). Because there are various categories of cooperative societies. One cooperative, your lordship knows, my lord, cooperative banks, primary agricultural cooperative societies. This is a housing society. And my lord, 14 will show this is a consumer cooperative society. The definition is there, my lord, means a cooperative society, the primary object of which is to supply consumer goods and to render such other services to its members and other consumers as may be required in the matter of supply and production of consumer goods, and includes a federation. Like, my lord, Somavaika, my lord, in Calcutta, my lord knows in Lindsay Street and other areas, there's Somavaika. Like, my lord, today's Spencer's and all these departmental stores, like Somavaika, they function as consumer cooperative societies. For the purpose of, my lord, they sell and trade in my lord, consumables, my lord, groceries, vegetables, fish, meat, everything. So that's a different class. Even then, my lord, if supposingly, my lord, as my learned friend has submitted,
why did the committee permit him?
Even if the committee permits, now I was coming to that. So at that point of time, he was himself the secretary of the society, and he prevailed upon the members then concur with his view. I do not know by what means.
No, the appellant was the president, wasn't he? Appellant?
At that point of time, I am not aware.
No, but you were a member of the governing body.
No, even then, my lord, there is a provision under the law itself. In a cooperative housing society, my lord, the general body of members, it's a supreme authority. Even if, my lord, for various decisions, my lord, nowadays in the new law, my lord knows, even for membership of a member, for transfer, letting out, induction of new member, my lord, formerly, the earlier law, which was in vogue, my lord, before 2006, my lord, then the society used to admit the member and send it to the Deputy Registrar of Cooperative Societies Housing for approval. This law has taken care, has, my lord, given a go by to that provision. Now the board is a supreme authority, and above the board, there is a general body of members, where all the members sit together in a general meeting or a special general meeting or an annual general meeting, and they decide. Even if, my lord, assuming for the sake of argument, that the general body of this housing society will not accorded permission to this gentleman to carry on commercial activity by converting his car parking space into a shop room. Now kindly comes to Rule 145 of the rules, 2011 rules. Rule 145. West Bengal Cooperative Societies Rules 2011, my lord. Subrule 1. Well, this is restriction on change in the scheme of the project and the number of projects in the housing cooperative society. No primary housing cooperative society shall undertake any housing project other than one decided upon in the promoters meeting for the purpose of registration of the society without the approval of the general body, and that very important, my lord, and concurrence of the registrar. This is where, my lord, I'd like to put my argument on that even if not for the sake of argument, let us proceed that the general body, all the members in this housing, they concurred with the view of this particular gentleman that all right, you convert the car parking into a shop and you carry on commercial activity from there. Even then, he could not have done so without the concurrence of the registrar. Registrar means, my lord, the registrar of cooperative societies. In this case, my lord will find that on the contrary, my lord, inquiry was held by the registrar of cooperative societies. The deputy registrar or some other officer subordinate to him was designated, and he or she, my lord, caused an inquiry. And the inquiry report said this is absolutely illegal. And to that, my lord, he himself wrote when this report was communicated to him. He himself wrote and said, this is a mistake on my part. That letter, my lord, will get. I'll just, if I may place, my lord. Kindly comes to, my lord, annexure P7 of the stay application, page 63. Page 63, my lord, my copy.
Letter dated.
This is a letter addressed to, the registrar of cooperation. It's a wrong, incorrect. This is the registrar of cooperation directorate. It is registrar of cooperative societies. Now kindly see, my lord, a copy of the letter under reference is received from the secretary of Bengal Pack Cooperative Housing Society Limited. And with reference to this letter, I like to state you that the consent of my cooperative society, I covered my car parking space as a shop at my cost. While all members registered their flat with parking space, I also registered my flat with shop unknowingly. My advocate was not knowing the Cooperative Act and rules in this matter. Now I came to know that it was a wrong action. I was given an undertaking to join JRCS RTAH earlier that I will not start anything or will not rent to anyone else immediately. But I was not told that it is bar according to the Cooperative Acts by JRCS at that time. In this context, I also like to state that I have not started any trade there yet. However, I am taking initiative to redirect the said shop to Bengal Pack Cooperative Housing Society lawfully very shortly. After completing the legal proceeding, I will intimate you and Bengal Pack Society accordingly. Well, there is a clear violation of Rule 145. And now, my lord, latest, my lord, now that hearing is going on before your lordships, I'm a little surprised this ought to have been told otherwise. I got the instruction yesterday that they have, yes, they have converted. Now what he has done is, he has discontinued his business, whatever he was carrying on, and he has now, my lord, handed it over to Airtel by letting it out. Airtel mini store. একটু জশা করে For this, I shall be citing a provision. For this also, my lord, concurrence of the society is necessary under the new law. When this was the parking area, since converted into a shop, and now being converted into Malad Airtel mini store. Whether these should have been appraised to your lordships.
Have you seen this? Do you know this?
Eto. He can take instruction. Well, I got this yesterday.
Matter is being heard by the appeal court. And your client goes and changes it again from.
During the, I am surprised.
From.
When your my lords are session of them.
Of course, we are not finishing today. But this conduct is enough for us to do a lot of things.
Firstly,
very improper.
All your eloquence has given a go by.
May I take the instruction first, Lordship? Then I'll submit.
Let him complete.
Let him
Mr.
complete.
Nandi complete.
Now, my lord. Now kindly comes to Rule 138, sub rule 1 of the rules, my lord. Rule 138.
Transfer and
This development is my lord, within last 4-5 days, as my lord's been hearing this matter. This Airtel. My lord, Rule 138 as placing, my lord, sub rule 1. This is transfer and letting out by members of a housing cooperative society. In all cases of transfer and letting out of land, house or apartment, although it doesn't state without any shop, written consent of the society shall be required. So now that this is a new development, we cannot put it into writing. We can file. I can always file with my lord's leave. I can file a supplementary affidavit, incorporate that photograph. That no consent of the society, nothing. Nobody was informed. This gentleman is so arrogant. He runs his own show. He doesn't care for anybody. Society, administration, none.
Yes.
And the scheme of the act will not, through the various provisions I have placed before your lordship, and kindly also comes to 93, section 93, my lord. Everywhere, my lord, will find plot, flat, or land. Your lordship will now find a shop or any commercial establishment. As respectfully placing, lord, section 93. Restrictions on letting out of house or flat by member in housing cooperative society. No member of a housing cooperative society shall, except under the following circumstances, be allowed to let out, my lord says, his house or flat allotted in his favor by the housing cooperative society. I'm not placing the rest, my lord. The reason I wanted to place to show your lordships that everywhere, my lord, it only puts the stress on the word house, flat, land, plot of land. Because even in housing, my lord, there are two kinds. One is a plot cooperative society where, my lord, the society buys large chunk of land, divides it into plots and hands over the plots, my lord, allots it, my lord, to the members for the purpose of construction of houses. Like in Jodhpur Park, my lord, in Golia.
Mr. Nandi, surprising, is there no case law at all to the effect that in a housing cooperative society, no commercial activity can be carried on?
Well, I also was trying to find, but I also could not find. But then I can show you, tell your lordship, even this can be done by dint of section 145.
I see.
145 can be done. General body will take a decision. concurrence of general body, and then registrar, because you are changing the scheme of the act. So for any change in the scheme of the act, without the permission of the registrar, express permission is required under 145.
No,
Can we-
145 perhaps.
145, my lord, the one in place, your lordship, because you are changing the scheme. For once, again, my lord, kindly comes to 145.
145 of the 2006 Act. Rule
The rules,
145.
my lord.
Rule 145.
2011 rules. This is one of the restriction on change in the scheme of the project and number of projects in a housing cooperative society. Because since the very scheme says that in a housing cooperative society, it has to be only a housing, residential purpose. So once the moment one tries to convert it into a commercial activity, so the scheme changes.
By one of the members opening a shop room, the scheme of the society doesn't change.
No, because the scheme, the original project, where at the time of formation, that of course,
Remains a housing society.
yes, no, but then the original the scheme, when one applies for the project at the time of formation, during the incorporation of the society, is that it will be a housing society only consisting of residential flats and car parking. My client might have that. I can, if a lordship gives me time, my lord, I can also try to find out what the initial documents which were used and filed before the registrar and also HIDCO, because in Rajarhat, at the time of incorporation, when the application was made. So that is all important. When I apply like in the bylaw is framed. The bylaw of the society also doesn't support this. So for this, now again, there is another point that since it is not there in the bylaw, he will have to now modify, because the bylaw, modification of the bylaw is also required. So one can always do that. Law provides for amendment of bylaws with the concurrence of the registrar. So without doing that, I cannot unilaterally will not change it. If I do that, then that becomes divorce the law. That's my respectful submission.
That is a change of user in the
Change of use. Absolutely, absolutely. Because in the original scheme, when applied, supposedly minimum 8 members are required for the purpose of forming of a housing cooperative society. All these 8 members act together. They form the project, submit the project report. They buy a piece of land, have it registered, applies before the registrar of cooperative societies, or maybe if it is in Rajarhat, also to the HIDCO authorities.
They are called the promoter.
Lordship?
They are called the promoter.
Initial. First, yes. And original members, the first members.
Where the promoters meeting, it is decided.
Lordship. They are the promoters, the first batch of 8 members. Subsequently, they may change, they can transfer, they can sell.
Founding members. Founding.
Yes, founding.
There is
Minimum 8 members are required for the purpose.
condition must be there. That is approval of the general body
Lordship.
and concurrence of the registrar.
That is, yes.
Approval of the general body is here,
Yes.
but concurrence of
Not there. Not there. So the moment concurrence of registrar is not obtained, and in this case, the registrar on the contrary has said what you have done is illegal.
Here, approval of the general body is there, or approval of the governing
I
body.
don't think so, governing body maybe. I don't think general body approval is there.
Not that there's no
The
general.
document which has been disclosed here does not show there's a general body approval. But governing body,
all members are the
naturally, my lord, I can understand it's a cooperative consisting of 8 members.
It's only 8 members.
Probably 8 members, 8 members.
Oh,
majority is in his favor in changing.
Yes. And the difficulty I told your lordship, probably what has happened, this NKT changing the plan, that they did not, when we made them, they said actually we did not have that idea that cooperative law does not provide for that. Because original scheme of HIDCO, it was when they are giving permission.
yes.
Because when when this Rajarhat was framed, conceived of, the original idea of HIDCO, that housing will be given, permissions will be given for construction of housing and multi-storied buildings. So naturally, there will be dearth of shops and all. The people who are going to buy flats or apartments there, for at least for daily needs, groceries, all these things, they are required. One cannot travel to 5 kilometers daily morning and for the purpose of buying and purchasing groceries. So that with that idea, my lord, basically HIDCO, the master plan, it was that housing come commercial complex. But now the problem is that cooperative law does not permit so. So only for in respect of those cooperative housing societies where they were given this permission, this was wrongly given. And that is the reason when we approach them that you could not have done this. They admitted yes, wrongly done. You apply, we revise it, and we applied for revision of the plan. And this gentleman, my lord, he rules the rules the way he is doing now. Matter is going on before your lordships. He doesn't care. But he converted it and now he has let it out. Even letting also that cannot be done within the punishable society.
There are
And even
only 8 flats in that complex.
8 flats. 8 flats.
Adjourn this matter today. Ask my learned friend to take instruction tomorrow. This is dangerous, my lord. This is dangerous.
And from this only, you might have an idea how he is and how he rules. How dare.
Going on hearing each and every day.
At least some idea he was present on the other day also. He should have had that much courtesy to tell before the court I have done this.
You have completed, Mr.
Almost.
I give reply. Just I shall not take more than 5 minutes.
No, let him come back tomorrow.
The main defense power which has been considered by the cooperative society, that common place have been registered in his name. That has not been answered by my learned. The observation of the register of cooperative society, common place have been registered in his own name. There are 2 violations. First is common place registration own name by
Which common space?
cooperative society common space.
No, he has converted a car parking space.
That has not been answered with. Kindly come to page 62, just for a moment. Page 62. That's not complete. Page 62. November 8th, 2019, after receiving my complaint, Register of Cooperative Societies, West Bengal. Subject affairs of the Bengal Cooperative Society, so Sanjay Banerjee, then enclosed please find here with a complaint petition dated so in original of Banerjee and Subhati so of that number so Housing Society Limited, while that the Polanra, the ex-secretary of the society, registered one portion of the society's common space in his name.
Is it vague? 1% of common space means where? You have to
Ground floor.
one
Common
portion
space.
of
It says common place. That has, I am coming to that. Common place with his apartment is registered in his name, along with his apartment. This is a gross violation of West Bengal Cooperative Society rules. Then kindly turn up to page 64. Next page. He has admitted. It's a common place. The answer last paragraph, only last paragraph. However, I am taking initiative to redirect the said shop to Bengal Cooperative Society. So this place is also belongs to the society.
He's referring about his car
Redirect.
his car parking space as a shop.
Two allegations. Car parking space, conversion to a shop, and registration of common place in his name.
Where does he admit that?
Redirect, kindly see. However, I am taking initiative to redirect the said shop to Bengal Cooperative.
Said
True,
shop
yes.
is in his car parking.
I am subject to
Said
such
shop.
process. These should be registered in the name of the society. He not only
The car parkings.
car parking space, encroachment, registration,
No.
conversion.
Please let us understand. The flat will be registered in the name of the flat owner. The car parking space will be registered in whose name?
Owner.
Flat owner. So the flat car parking space that he had converted it into a shop.
Why? In addition to that, encroaching the common space.
Where is that encroachment issue?
That I have also in my complaint, that is also there.
That is what my brother said. That is absolutely bald and vague.
No. Kindly see. The registration has been done so far the common space is concerned, and that is last paragraph. However, I am taking initiative to redirect. Kindly consider. It should not be redirect. The said shop to Bengal Cooperative. If it is he is the owner of the entire portion. The question of redirecting the same in the name of cooperative does not arise.
Now, you tell me. This is a vague admission on his part. You tell me, apart from car parking space, which portion he has enclosed?
Adjoining common portion.
That has not been mentioned in your letter 8 November 9.
In my complaint that is there. In my complaint that is there also.
Let
That's
them
why I
show
want
the
to know.
registered deed. Let them show the registered deed. The way I have submitted lordship, let them show the registered
Come to
deed.
page 58, just for a moment. Kindly, what is my complaint? Page 58. 58.
So instead of car parking space, it has been registered in.
No. Kindly come to page 58.
This is for the first time this question arises,
No,
lordship.
no, this is my
Neither in
complaint, sir.
writ petition nor in appeal, nowhere it is mentioned.
Kindly come to serial number 2. Everybody kindly see parking space 135 square feet. And so far Kollanara is 138.2 square feet.
3.2 square feet.
138 square feet.
He is entitled 135,
Yes,
but he acquired
3 foot and 2 square
3.2
foot
square feet.
additional.
3 square feet.
Yes.
What
That is
does
an
what?
allegation at that.
No, please, Mr. Venkata. What does soap mean? Soap.
Parking. That will be parking area.
Shop area. Shop area.
So, my lord, additional area from the cooperative society has been.
But additional payment is also shown. 91,164.
You see, it was transferred.
You have made your submission.
But
You also take instruction. Come back on Monday.
tomorrow.
Not tomorrow.
Well, may I show just one indulgence, lordship? That I'll not drag this matter, lordship. I'll take the instruction.
All indulgence we will grant you, but you first take instruction on this. If this has happened, we take a very serious view of this
Lordship,
matter.
definitely. Lordship, I'll even.
And as a counsel, you will also appreciate it.
Definitely.
As an officer of court,
Definitely.
this is sort of overreaching the court.
Definitely.
Without taking your legal advice, he has done this.
Lordship, I don't, because he told me that the way I have submitted, lordship, that it was letting to someone else and generating income from there on. That was my submission, lordship. I will take that instruction. I'll definitely come back.
Mr. Lekho. Mr. Nondi, learned advocate representing the society, housing society, concludes his submission. Paragraph, list the matter once again. Let it be tomorrow, whether it's taken up or not, we don't know. Kalki date deta for further hearing.
All has to be mentioned. Better valid. To give the instruction.
Not as to be mentioned. Yeah? Appellate side to first half it. যদি হয়ে যায় যাবে। Appellate side first. হবে পৌঁছবেই না দেখো।
কোথায় আসছে এখন রিমেন ইটস পজিশন to remain forward.
As forward as well tomorrow.
No.
Regular list.
Under the heading specially fixed. Specially fixed matters.
Yes, because since we have completed hardly 5 minutes now.
Yes. Immediately after the application, specially fixed matters are taken up.
Obliged. Grateful.
T and 32.
To afresh your lordship's memory, these two appeals by my client, again, this is a third round of litigation. I have submitted on the last occasion before your lordships, and I have shown certain orders passed by this honorable court from time to time, including 2 orders passed in contempt initiated by my client. But what happened, the respondent number 6, who has also prepared an appeal, which is item number 31, I believe.
Shipra.
My lord, she has constructed, initially it was a 1-storied building. Ultimately, he raised up to 3 stories. And admittedly, my lord, the building stands on a land of half katha, 8 chucks. Under the my lord, Panchayat Act, my lord, no construction can be made in 8 chucks of land. Far up to speak about that, my lord, he had never applied for any permission from the Panchayat authorities. Instead, my lord, raised the 3-storied building. Now, my lord, when in the year 2000, for the first time I came before this honorable court, I am the adjacent landowner. My lord, myself and my wife, 2 contiguous plots of land. My lord, initially there were 2 buildings. Subsequently, I have applied for amalgamation. There was an registered deed of amalgamation. Then I applied for revised plan before the Panchayat authorities for my lord, revision by amalgamating 2 plots and raising from 2nd floor, raising the 2nd floor on the amalgamated plot. That application I made way back in the year 2006. My lord, 2006 till 2013, they never raised any objection. And there is a specific provision under the Panchayat Act and Panchayat rules. Rule 30 says that there's a deeming clause, in fact. But unless a permission or refusal is granted within 60 days from the date of application, it will be deemed that he has done it authorizedly. My lord, by application of that deeming clause, my lord, I raised the construction of on the 1st floor, and I am residing there. Now, my lord, on the first writ petition, there was a direction by this honorable court that if to cause an inquiry and if there is found any illegality in the construction of the respondent number 6, law will take its own course. But nothing was done. That order was passed way back in 2008. But even after up to 2013, no steps were taken. Then, my lord, I came the second writ petition for non-action on the part of the Panchayat authorities to take any step for demolition. In terms of a particular letter, I'll show. My lord, in fact, I'm giving the gist for your lordship's refreshment. Now, my lord, the second writ came. But when the second writ came, that was finally heard by my lord Justice Soumitra Pal, as his lordship then was. During that application, in course of pendency of that application in 2013, suddenly Panchayat woke up and found, upon an inspection, found that some portion of my amalgamated building is illegal, according to Panchayat, is illegal. So they gave us a notice, called for a hearing. All these things took place. Ultimately, Justice Pal held, yes, the building of the respondent number 6 must be pulled down immediately. And as far as the allegation as against my client is concerned, to cause an inquiry, inspection, and whatever the law says, law will take its own course again. Then, my lord, the battle really starts from 2013. Today, we are in 2023. After 2013 order, nothing was done. Contempt applications were moved. In 2 contempt applications, one of the contempt applications, he was the Panchayat, the Pradhan, the then Pradhan, I'm sorry. The then Pradhan, pursuant to the direction of this honorable court, personally appeared before this court and admitted, yes, it is a fault on the part of the Panchayat, but I was not there at the relevant point of time. I have been newly elected. So kindly allow me some time. I will take steps for carrying out the order of the court for pulling down the structure of the respondent sex. That was done in 2012. 2013, subsequently, the 2013 order was passed. Nothing doing. In the meantime, what they did, the third battle of litigation, which is before the lordships, in the third battle of litigation, they give us a notice saying that this part of your construction is also illegal. And by a common order, they directed the respondent number 6 to pull down the entire structure. And so far as my client is concerned, to demolish the alleged illegal construction. But against that, my lord, I have come before this honorable court. The honorable single judge passed an order, but without, although it's a big order, without going into the main controversy, the issue, the simple order was passed that yes, whatever the law says, Panchayat will do it accordingly. Meaning thereby, in my humble submission, subject to correction, meaning thereby that the higher structure will be pulled down. At the same time, my illegal construction should also be demolished. Entirely it was left to the panchayat. Against that, my lord, I have come before your lordship. In the meantime, my lord, the matter was heard by at least 3 honorable judges of this court. My lord, Justice Vishwanath Samadar, as his lordship then was, in one order I have annexed it in the appeal statement. Justice Samadar held that in terms of Rule 30 of the West Bengal Gram Panchayat Administration Rule 2004, it is a mandatory provision that when the statute has empowered given the authority of the deeming clause, the deeming clause will squarely apply in this case. Well, at that juncture, they made an application for recalling of the order. The Panchayat made an application for recalling of the order, but that application was dismissed for default. No steps taken, no appeal preferred. Application gone. Now, my lord, in the meantime, this matter was heard once again by my lord Justice Horace Tandon. My lord Justice Tandon has passed a big. In fact, on the last occasion, I was placing Justice Tandon's order. I think, Lord, I should place this order. Everything will be clear to your lordship. Where is my paper? Your lordship need not know. This order will speak everything. Page 109. Kindly come to page 109, the first appeal. Yes. But I'll give your lordship some trouble in reading this order because each line in my humble submission, each line of this order is important. But kindly allow me to go through. The present petition is filed by the petitioner challenging a so-called notice. My lord, got it? 109, page 109 of.
This is the first writ petition or the one from which this appeal has come arisen?
This is the third writ petition from
Third
which
writ petition.
from which the appeal has arisen. The present writ petition is filed by the petitioner challenging a so-called notice dated so and so issued by the Assistant India. My lord, your lordship, kindly skip, my lord. Kindly come to page 110 at the bottom portion, last paragraph. This led to another round of litigation at the behest of the petitioner in filing WP number so and so. This is the second writ petition. The petitioner not only sought a direction upon the Sabhadipati Howrah Jilla Parishad to implement the order of demolition of structure allegedly constructed by the respondent number 6, but also that the Jilla Parishad cannot act on the basis of the alleged complaint made by the respondent number 6. But I'm pausing here for a moment. But as far as my alleged illegality is concerned, but that complaint was raised by the respondent number 6 herself. Respondent that is also annexed here. I will show to your lordship. But at her behest, my lord, steps were taken against me after 13 years, 2000 to 2013. And the copy was given to me. As the same is made with malice and as a counterblast. While disposing of the said writ petition on 4th September, so and so, this court not only directed the Pradhan to implement the order of demolition passed against the respondent number 6, but also directed inquiry to be made in relation to the complaint made against the petitioner and to bring the dispute to an end with a specified time. But that includes me. It appears that in compliance of the said order, the impugned so-called notice is issued upon the petitioner as to why an order of demolition be not passed against the petitioner in respect of a portion of structure which allegedly found to be illegal and wrongful. The petitioner has challenged the so-called notice on twofold grounds. Firstly, there was a similar so-called notice issued earlier and the reply was duly filed by the petitioner, but thereafter no steps were taken by the Jilla Parishad and therefore the similar and identical so-called notice is not maintainable. Secondly, it is submitted that the so-called notice is vague and cannot be sustained. Now kindly skip. Kindly come to page 112. This is very important. The third paragraph. However, this court appreciates the agony and anguish of the petitioner that after issuance of the so-called notice in the month of November 2013, no steps or further steps have been taken as yet. It is really a matter, kindly take note of this sentence. It is really a matter of great concern that the statutory authority is sitting tight over the matter and nearly 5.5 years has expired since then and the matter has not been brought to its logical end. This court therefore directs the concerned respondent to dispose of the proceeding allegedly initiated on the basis of the so-called notice within 6 weeks from the date of so and so, so and so. Then kindly again skip the last paragraph of this page. So far as the primary relief claimed in the writ petition is concerned, it is really alarming that despite a final order having passed by the Jila Parishad for demolition of structure allegedly made by the respondent 6, no steps have been taken as yet. In fact, this court directed the concerned respondent twice to implement the order of demolition, and it is equally disturbing that in spite of a candid and express submission made before this court in an earlier petition that the Pradhan would implement the said order, yet the implementation is far away from its destination. The statutory authority taking a specific stand before the court cannot take the court for a ride, and sixth, basing that there was a bona fide mistake and oversight in implementing the same. If the Pradhan who claimed to have been elected in 2008 openly asserted before the court that she was not aware of the order passed into the year 2000 and assured the court that she would implement the said order, it is inconceivable and unbelievable that such Pradhan would show least respect to the positive stand taken before this court. This court is not unmindful that the tenure of the Pradhan is limited, so and so. This court, the last part, one paragraph, this court therefore directs the Sabadipati Howrah Jila Parishad to implement the order of demolition dated 26 July 2011 within 2 weeks from the date, and shall file the compliance report before this court on the returnable date. But appeal has been prepared. Appeal is before your lordship. Your lordship was pleased to stay. Demolition of my portion has also been directed.
This is the order impugned in this appeal. This is the impugned order.
No. After that, what they did? After that, my lord, a final order was passed. My lord Justice Tandon directed for re-hearing of the whole issue. Then a final order was passed, which is under challenge before the writ court. Page 166. Page 166, my lord. I'm sorry. Yes. No. This is an order. The impugned, your lordship is looking for the impugned order.
Yes.
Not at 166. At 166, not everything has been stated. Your lordship need not go through the entirety.
No, let us see the order because
Yes.
that will give us the factual background.
Yes. Should I read out? It's a big order, quite a big order. My lord, number of judgments, my lord, although not cited by the party, either of the parties, my lord was pleased to refer to number of judgments. My lord, in my humble submission, some of the judgments do not apply in this case at all. I shall try to distinguish that also. My lord, yes, in fact, this order is necessary for your lordships.
Read it.
My lord. Affidavit in opposition to the writ petition filed on behalf of the respondent number 4 as also the respondent number 6 are taken on record. The learned advocate for the petitioner submits that the petitioner does not want to use any reply. The writ petition has been filed by a person who assails a notice of demolition dated November 2023 passed by the assistant engineer Howrah Jila Parishad. That is my application, the third writ petition. A portion of the building which was constructed by the petitioner was found to be beyond the sanctioned plan. So and so the area has been quoted. The authority indicated the extent and nature of the unauthorized construction in the impugned notice as quoted above. The said notice is composite one, which includes direction for demolition also upon the respondent number 6, who is the writ petitioner in so and so, and also the husband of the petitioner, the Sukhdev Kumar, the other appellant before your lordship. From the inquiry report dated November 7, 2013, it appeared that behind the building of the petitioner, another G+1 story structure has been raised by the husband of the petitioner, and both the buildings were joined together and interconnected. As I submitted, my lord, this is by virtue of an amalgamated plan and keeping in mind the deeming clause. The said building also had a covered area of more than 90%, which was not permissible in law. Sukhdev Kumar has not challenged the order of demolition. The respondent number 6 has challenged the said order by filing WB number so and so. A separate petition. The petitioner contains that after the construction was completed sometime in 2005, a revised plan seeking regularization of the deviation from the approved plan has been submitted before the Panchayat. Reliance has been placed on a receipt dated so and so. The petitioner justifies the construction and retention thereof by invoking Rule 30 of the West Bengal Gram Panchayat Administration Rule 2004. The Landed Council submits the revised plan was submitted before the Gram Panchayat on May 22, 2006. It is submitted that the petitioner did not hear anything from the said authority for more than 30 days. By operation of the deeming provision, the petitioner has acquired the right to retain the portion which was constructed beyond sanction. Landed Council submits the regulation was automatic in this case as the authorities kept silence over the issue. The silence amounted to post facto sanction. Reliance has been placed on a decision of the matter so and so. But I shall place this is a judgment of my Lord Justice Pranab Kumar Chattopadhyay as his lordship then was. The petitioner further submits that different benches in several rounds of litigation had directed the Howrah Jilla Parishad to demolish the structure raised by the respondent number 6, but there was no mandate upon the Howrah Jilla Parishad to direct demolition of the alleged unauthorized construction of the petitioner. Reliance has been placed on an interim order passed by a coordinate bench of this court in this petition. At the interim stage, there was an observation that the provision of Rule 30 of the said rule was squarely applicable in the petitioner's circumstance, but that is the order of Justice Samatar. Reliance has further replaced of an order dated June 13, 2018, passed by another coordinate bench. It is submitted that his lordship in the order dated June 13, 2018 did not make any observation with regard to the implementation of the order in respect of the petitioner's construction. Hence, it is argued that the allegation against the petitioner was not substantiated and there was no direction upon Howrah Jilla Parishad to take step in respect of the petitioner's construction. Mr. Bhattacharya, learned advocate appearing on behalf of respondent 6, admits that the said respondent did not have any sanction from the authority. He further submits that from 1985, the Howrah Jilla Parishad was the authority competent to grant sanction as per the Panchayat Act and the bylaws of the Howrah Jilla Parishad. The respondent 6 did not apply for sanction as the plot over which the construction has been made was very small and did not meet the criteria as per the building rules and the bylaws of the Jilla Parishad. However, Landed Council prays for regularization. Mr. Bhattacharya relies on a decision of the Honorable Division Bench of in the matter of Ajaynath Jabot, so and so. My Lord, pausing here for a moment, your Lordship sitting in this jurisdiction, my Lord, a month back was pleased to, my Lord, decide on this point and relying on this judgment that this is not applicable in this case and the structure should be immediately pulled down. And I have also that copy of the order. Your Lordship has decided. The Honorable Division Bench directed the building committee of the Howrah Jilla Parishad to consider the prayer of regularization made by the appellant in the said appeal in terms of Rule 15 of the bylaws of Howrah Jilla Parishad. The learned advocate for Howrah Jilla Parishad submits that by an order dated September 4, 2013, another coordinate bench of this court had disposed of a writ petition being numbered so and so. This is my writ petition filed at the present writ petition with a direction upon the Sabhadipati Howrah Jilla Parishad to demolish the unauthorized construction raised by the respondent number 6 within a period of 8 weeks from the presentation of the certified copy of the order and upon granting a notice to the respondent number 6. With regard to the allegation of unauthorized construction undertaken by the petitioner, his lordship found that the same was evident from the report filed by the authority in the said proceeding. His lordship directed the authority to inquire into the matter and take steps for demolition in accordance with law if such construction was found to be unauthorized. Such steps was also directed to be taken within 8 weeks. It is submitted that on the basis of such direction, the impugned notice was issued. This impugned notice was under challenge before the Honorable Single Judge. It is next submitted that the order dated June 13, 2018, directing the Howrah Jilla Parishad to implement its own order wrongly mentioned as July 26, 2011 instead of July 18, 2011 by his lordship. Both the petitioner and the respondent number 6 were asked by the Jilla Parishad to demolish the illegal and unauthorized construction raised by the said parties in violation of the sanction plan and the bylaws of the Howrah Jilla Parishad. The Howrah Jilla Parishad was authorized to finally demolish the structure as all the courts had directed demolition of the structure constructed by the petitioner, which was found to be beyond the approved plan And not only the construction of the respondent number 6, which is admittedly without sanction, not in my humble submission, the recording of this part of the order is also not correct factually. It has been averred in the affidavit in opposition filed by the Howrah Jilla Parishad that both the constructions were unauthorized. A further report has been filed along with the affidavit in opposition, which indicates the extent and nature of the unauthorized construction of the parties, as also the husband of the petitioner. The same is a recent report. It is also clear from the report that the order passed by the Howrah Jilla Parishad that the amalgamation of plots, which was prayed for by the petitioner and her husband, has not been allowed. The coordinate courts also noticed that both the parties have raised unauthorized construction and has directed implementation of the order of demolition. The petitioner refused to file affidavit in reply. The Howrah Jilla Parishad specifically stated in paragraph 7 of the opposition that regularization as prayed for by the respondent number 6 could not be allowed due to insufficient clearance. In order to ensure safety norms and protection of life and environment, the structure of the respondent number 6 could not be regularized. Lord, this was the submission of Jilla Parishad. Heard the learned counsel appearing for the respective parties, there is no dispute with regard to the fact that inspection by the competent authority, that is the Howrah Jilla Parishad, revealed that the constructions are illegal, irregular. The extent and nature of irregularity in the construction of the petitioner has been mentioned in the impugn notice and also in the current report. The construction of the respondent number 6 without any sanction is wholly illegal, while the petitioner claims post facto regularization on the basis of deeming provision. The respondent number 6 claims that the matter may be sent to the building committee of the Howrah Jilla Parishad for consideration of the prayer for regularization. The Howrah Jilla Parishad has been consistent in its fighting with regard to the unauthorized construction of both the parties. Since 2011, the Howrah Jilla Parishad has been trying to implement its own order of demolition upon detection of unauthorized construction. It was at the petitioner's instance that the Howrah Jilla Parishad was activated to inspect both the premises in order to detect irregularities in the construction. When the portion of the petitioner's construction was found beyond the plan, the petitioner was issued several notices. The petitioner claims protection of the deviated portion by application of Rule 30 of the said rule. The law is well settled in the field. Retention cannot be claimed as a matter of right. Unauthorized construction or part of construction or beyond the sanction plan must be demolished. Then, my lord, several judgments, my lord, your lordship will kindly skip, my lord, in my humble submission, my lord, some of the judgments do not apply in the facts of the present case at all. Commercial. And all the judgments cited the recent trend of the Supreme Court, starting from Priyanka Estates judgment reported in 2005 volume 9. My lord, all these judgments relate to, my lord, developers, builders. There the Honorable Supreme Court was pleased with a number of judgments referred here that an individual should not be equated with the commercial promoters. Not that actual place. Not that those principles have been applied by the Honorable Single Judge in this matter. Now, my lord, kindly stay. The last portion at page 186 of this judgment. Under such circumstances, the writ petitioner disposed of without any orders in favor of the petitioner. My petition without any order. The Howrah Jilla Parishad shall be free to implement its own orders as already directed by the coordinate benches in accordance with law within a period of 12 weeks from the date of communication of this order. But this is in finality, and the Honorable Single Judge was pleased to hold that Rule 30 of the West Bengal Gram Panchayat Administration Rule does not apply in this case at all. And as far as the reference before the building committee by the respondent number 6 is concerned, as I submitted, your lordship was pleased to inquire on this issue and found that no reference can be made to the before the building committee, and building committee has no right to do it. Meanwhile, my lord, what that happened, my lord, the building rules have been changed by virtue of a resolution taken by the Howrah Jilla Parishad. There are certain provisions that are there, including the provision for regularization of small unauthorized construction. Lord, I shall come back. Lord, I don't think, Lord, your lordship, should I continue, Lord?
Yes.
Yes, sorry, my lord, this is the. No, I'm sorry, my lord. Still, we have 15 minutes time in hand.
Yes.
Now, my lord, this was the order. My lord, in my respectful submission, the first point which should be looked into in this matter is whether, my lord, at all Rule 30 of the West Bengal Gram Panchayat Administration Rule applies. And then, my lord, the next issue would be when I applied for the revised sanction plan and Panchayat or Jila Parishad authorities has accepted, rather received the revised plan, asked me to pay certain fees, which I have paid, that is on record. After that, after waiting for about 8 years, only at the instance of the respondent number 6, whether any proceeding could at all be initiated in the form of a second so cause notice, identical to the first so cause notice as found by my Lord Justice Tandon, whether that is permitted at all. And thirdly, my lord, if at all Rule 30 applies, but Rule 30 is, in my humble submission, it is statutory rule. It has got a statutory force. My lord, it flows from the original act. Unless the act is there, my lord, no rule can be there. So in aid of the act, when a rule is framed, it gets a statutory force. And the law of interpretation of statute says that when the statute has made this provision, it has to be carried by all the courts.
On what ground did the learned judge say that Rule 30 will not apply?
My lord, that is the only 2 sentences is there. My lord, kindly give me. কোথায় দাগ দেওয়া আছে দেখো তো জসেফ দু জায়গায়
Page 178.
178. My lord, I am grateful to your lordship. Well, in fact, yes. But should I read this paragraph? The question of deemed sanction would not arise in this case as the petitioner admittedly completed the construction and then allegedly applied for regulation before the Thana. It is nobody's case before the single judge. It is nobody's case before the single judge. No affidavit has been filed either by the Jila Parishad or by the respondent number 6 to this effect. Moreover, there is nothing on record which would show that such application had ever been made. It is there in the writ petition itself. The Panchayat Act also does not provide for regularization. The petitioner all along moved the Howrah Jila Parishad for grant of sanction and for the renewal. The renewal was applied for in 2005 and was granted up to 2007. But that was the initial sanction. Thus, the plan which was renewed up to 2007 was the final plan. Rule 30 of the said rule does not apply. The petitioner's case is that the revised plan was submitted in 2006 before the Panchayat. This is contrary to the fact that the plan of the petitioner has been renewed up to 27 by the Jila Parishad. Pausing here for a moment. If I, apply for a sanction and sanction is accorded in my favor up to a particular year, I am putting the question to myself whether I can at all apply for a revised sanction plan during the period tenure which has been already sanctioned. I am putting it the question to myself.
No, you see, Mr. Ghosh, what the learned judge seems to be saying is that deemed sanction, the concept of deemed sanction and regularization are entirely different. The question of deemed sanction may apply, or the concept may apply, when before starting construction, you have submitted your building plan. Within 30 days or 60 days, whichever period, there is no response. You can then proceed on the basis that your plan has been sanctioned.
My lord, I have applied for the revised plan in 20.
No, the learned judge, rightly or wrongly, we have not yet decided, says that you submitted your revised plan after making the construction. The concept of deemed sanction will not apply in such a case. This is more a case of regularization,
which is permitted under the new bylaw.
No, that is different, but Rule 30 will not apply.
Rule 30, my lord, in my humble submission, my lord, up to 2007, my lord, my sanction was there as held by lordship. Up to 2007, I applied in 2006. 1 year prior thereto, when the sanction was already there. My lord was pleased to hold that since the sanction was already there, there is no question of revised plan.
No, sanction was there, sanction actually sanctioned or deemed sanctioned?
No, actual sanction.
Actual sanction.
Actual sanction was there till 2007. And I applied for regular revised plan in 2006.
Because your construction was in deviation from the
Yes,
sanction plan.
original sanction plan. That is why I applied for revision, which was pending for even today that has not been revised.
This is what she says. She says Rule 30 will not apply to this revised sanction plan. Rightly or wrongly, we are not deciding. This is what she seems to be saying.
My lord, apparently looks so, but the revised plan, in my humble submission, revised plan is also a plan. My lord, rightly or wrongly, my lord, whether I have made the construction prior to 2006, that is nobody's case. Nowhere it is available. That I constructed prior to 2006 and then I applied for the revised plan. It is nobody's case. Nowhere. Still, whatever, my lord was pleased to hold. It seems like that yes, I constructed first, then I came for revision. Even assuming that, my lord, under the new building rules adopted by the Howrah Jila Parishad, even construction is made that can be regularized upon payment of. My lord, I'll show you. Lord. I'll show.
2005.
2005. With effect from. With effect from 2009.
Clause 15.
Yes. But, rule 15, I showed.
Rule 15.
কোথায় গেল তো ভাই? Yes, it is there. Yes. জজ সাহেবকে আমি কপি দিয়েছিলাম বোধ আগের দিন. Yes. Yes, my lord. My lord, the running page is 23 of this rule. Your lordship is pleased to look into this. Rule 15, if any building is being constructed, assuming, my lord, I was constructing at that point of time, without sanction from this Parishad before the bylaws came into force and without any permission from Panchayat level, the applicant may regularize the said case from the Parishad by submitting as-made plan. My lord, as-made plan in my respectful submission, whatever I have constructed, I have submitted the as-made plan. In fact, the revised plan which I have applied for is an as-made plan in terms of this regulation with the development fee for residential business, so and so, so and so. And receipt were issued.
That applies to buildings which you have started construction,
My lord.
prior to the bylaws coming into force. Read the first two lines again.
If any building is being constructed,
Is being constructed, it says present continuous. It is being constructed at any point of time prior to the bylaw coming into force.
then come to rule 16. Old houses which have clearances from the boundary lines which is not within the rules of Jila Parishad and where setback is not possible. If with setback there is a possibility to collapse of the building, in that case, Jila Parishad will accept the drawing and sanction will be given duly after taking a decision of the building committee meeting. This rule will be applicable buildings up to 7 meters high. My lord, so far as the respondent number 6 is concerned, my lord, even assuming that they tried to submit, I do not know what Mr.
Who is for number 6?
Mr. Nilanjan Bhattacharya was there. He was appearing.
Anything on record to show when you made the construction?
Nothing on record. My lord, I shall further check. But according to me,
But you know when you did.
my lord, I think there is nothing. Still, I must be candid before your lordship. Kindly give me a day's time. I shall come back.
Your client will not tell you because he'll be in trouble.
No. It will everything will appear from record. Everything will
Try
appear.
to get that. Because if the construction was made after this bylaw came into force,
Yes.
may not apply. Anyway, you try to find out. We'll rise 5 minutes early.
না না ও যে ক্লায়েন্ট কি বলবে ক্লায়েন্ট সবসময় সত্যি কথা বলে নাকি
Tomorrow, it'll now come under the category specially fixed.
Specially fixed tomorrow.
Mr. Sandeep Ghosh, learned senior counsel representing the.
My lord, may I request your lordship one thing, Lord? In earlier occasion also, my lord, in the order, your lordship regarding the learned senior, kindly do not do that. I am not a designated senior.
Therefore, I never say senior advocate. Learned senior counsel appearing for the appellant in Mat 42 of 2023, resumes his submission but does not conclude tomorrow.
Tomorrow.
Paragraph lists the matter once again. Kalke date diye dao. Under the heading specially fixed matters, for further hearing.
Specially fixed money আগে হবে, application এর পরেই হবে। থাকলে যখন হবে তখন হবে। লাভ আছে।